Good morning, everybody. Happy Tuesday. Welcome to TCF Live. A special shout out this morning to Ellie, who was kind enough to completely disconnect and destroy during the pre-show. Apologies to those of you who are on the pre-show. We had a good discussion going. We'll start it over tomorrow. Anyways, let's start our day here in the big show with Judge McNally.
Ashby, Jennifer Marie Ashby, 25W838597 LVMV versus Hageman will be next. Your name, ma'am?
Jennifer Ashby.
Where you been?
I was unaware of the warrant. I had some arrest.
Did you get your ticket?
I didn't get anything. I believe that.
Hang on a second. You got written for impeding traffic. The officer handed you the ticket.
No, I was not driving my vehicle. I believe it was my roommate that was driving the vehicle upon the ticket. And she lives with me, so I didn't receive any mail, and I was pulled over and they said there was a warrant for my arrest. So I'm here today.
This wasn't you driving?
No.
Well, I can't listen. Here's what I can do. Can you post $237?
No, I was coming here to take care of trying to make a payment plan.
Well, why would you make a payment plan? Listen to me. This is a courtroom right now, okay? It's a courtroom. Why in the world would you come in here and ask me to give you a payment plan if you weren't the one driving? Did you hear what I said?
Yeah. I don't want the warrant for my arrest.
Hang on. Were you driving or not driving?
I was not driving.
Why would you come in here and ask for a payment plan if you weren't driving?
That's what the officer said to do.
The officer said to come in and ask for a payment?
Take care of it.
Slow down. What officer?
I was pulled over yesterday in a car and they ran my name.
Did you tell him or her that you weren't driving on this date?
Yes, and they said to come to court, open court to take care of it, and that's what they
No,
told me.
I thought you just said the officer told you to come in here and make a payment.
To take care of it. Yes, that's what I'm here to do.
Ma'am, I need you to post a bond. I'll be glad to entertain a motion to set aside default, but the rules are the rules. And you have to file a motion. And it doesn't have to be lengthy. They have them down there, and post a bond equivalent to the amount of the judgment, which right now is $237. Are you still maintaining you weren't the driver?
Yes.
You have a credit card you can put this on?
No, I brought $40 to make a payment. I don't have it.
Why would you listen to me? We don't live in Russia. I know it's just a civil infraction, but you don't come in here and start paying tickets if you weren't the driver. Now, your friend's going to have a problem because she's going to get charged with false information to an officer. You understand what I'm saying? You post $237 within 7 days, and you fill out a motion. I think it's seven. You post 230. Go borrow some money. Come on back. File a motion to set aside the default judgment. Okay? You can go right down the hall. I'm not taking your $40 now. Save that for towards your 237. Okay? You shouldn't be coming in here. You don't want this up. No, it's not. Come on. I hope you guys people have more confidence in the judicial system than that, where they think if somebody uses their name and writes their friend a ticket, and the friend doesn't split. That is, I hope you're still friends with this girl?
Well,
Are you still friends with this girl?
friends with me.
All right, well, how can you be friends with somebody that just got you in trouble by giving false information to a police officer? I'm just telling you, I'm not going to give you advice on who to choose and not to choose as friends, but somebody did that to me. Get out of my house and evict if you have to, and you're done with me. What kind of friend is that? Who needs enemies if you got friends like that? 237, post it within 7 days. Come in, file a motion. Okay, good luck to you. I wish you well. Listen, we're going to treat you fairly, but You have to write in the motion that this wasn't you and you just found out on January 12th when the officer pulled you over, okay? Make sure you come back with that money. Good luck. LBNV versus Thomas Hageman, 2503867.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Good morning. Mr. Hageman, your name, sir?
Thomas Hageman.
All right.
Good morning.
We're going to conduct what, a pre-trial today? Is that what we're doing?
We don't need to, Your Honor. This case is resolved. I personally am in possession of Mr. Hageman's signed consent judgment. So we can file that on e-file today at some point.
Okay, is that true, Mr. Hageman?
Yes.
Okay, so you're going to file that today, Mr. Stratton?
Yes, Your Honor. Someone will file that today.
Okay, I guess I need you to state your name. I don't know if you did. Maybe you did and I missed it.
Mine, Your Honor?
Yeah, maybe you did and I missed it.
Yeah,
don't
I did.
know.
That's okay. Trevor Stratton, P65124.
All right, send it over. You guys are all set. I wish you well. Thank you. Jeffrey J. Twardzik versus
Thank you, Judge.
Priority Waste, 2503946R.
Good morning, Your Honor.
Good morning. Mr. Twardzik, your name?
Jeffrey Twardzik.
Where is somebody from Priority Waste? I don't see
Your
any.
Honor, they have not checked in this morning.
What
And I know this was a review, so I wasn't sure if,
review for what? Did we not get a judgment when we were supposed to get a judgment?
no, I believe there was an arrangement or an agreement that was made. We were waiting on
Did we get the
parties to
paperwork? Did
exchange.
you sign the paperwork yet, Mr. Twardzik?
Your Honor, I did not because I have not received payment yet, and I advised that to the attorney, Mr. Dillon.
Call Priority Waste. I want him online, please, Jennifer. Zeal
Okay, I'll call
Credit
Mr.
Union
Dillon.
versus Carrie Moore, 2504152. Did you get a hold of Ms. Ford, Jennifer, or Lisa?
She's here.
Yes, he just walked
Okay,
in.
good. Do I have somebody here from Zeal?
Yes,
Ms.
good morning, Your
Solomon,
Honor.
Good morning.
Yep.
Your name?
Alexis Solomon, P87454, appearing on behalf of plaintiff.
All right, Ms. Uwe?
Good morning, Your Honor. Jocelyn Uy, P64890 on behalf of the defendant.
Good morning to you. Today is the date scheduled for pretrial. Do you guys just want dates or did you resolve it?
We would just like dates, Your Honor. We are resolving. We're in settlement discussions right now.
Can I have a pretrial order, please? Or do I have them up here? Oh, here. Okay. All right. So let me see here. Is there a defense to this, Ms. Uwe?
Your Honor, it's the intent of the defendant to make the repayment plan. We're just trying to iron out the final
Can I just
details.
set this for trial or do you guys want discovery?
I'm gonna leave that to
Discovery.
plaintiffs.
Yeah, discovery if possible.
All right. Discovery cutoff will be on March the 1st of 26. No ADR, no motions date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. No jury. We're going to give you a trial date in latter part of March. I'll put down estimated time for trial 1/2 hour, and you do have to file your witness list by February the 6th. So February 6th, the 26th witness list due. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial. And I also have, let's see here. Deal, let's see. What's the trial date gonna be? End of March, I'm thinking,
Judge, April 7th at 10:30.
April 7th at 10:30. Okay? So I'll
Thank you,
send
Your
this
Honor.
out to you guys. And you need this part.
No.
Okay. So we'll send this out. Anything else, Ms. Solomon?
Nope, that's it. Thank you very much, Your Honor.
How about you, Ms. Uy?
No, nothing else, Your Honor.
Sorry.
Thank you.
Katie, here you go.
Good morning once again, everybody. Welcome to TCF Live on a Tuesday. Chaos Gremlin Ellie is now sleeping, so hopefully this show doesn't get disconnected like the pre-show, although she is sleeping on my network cables, so fingers crossed. Courts are just now starting to come online. We'll continue for now with Judge McNally.
By Monday.
Why are you guys waiting so long? When were you here last? Mr. Twardzik, I need your name.
Jeffrey Twardzik.
Just because of bookkeeping and the holidays and being behind, and it's not, I'm just waiting.
I'll adjourn it 2 weeks. This is a review hearing date again.
Okay.
So
Mr. George, we're sending you the entire amount to you. You pay who you like. Okay.
That's fine.
what do you have for me, Jen?
The 27th at 9:30.
Remember, that's the day I have court to school, right?
Yep.
Okay, 27th at 9:30. Thank
Okay.
you both. Have a good day. Thanks.
Appreciate it. Thank you.
First National versus John Kovacs. First National, are you ready on yours? What are we doing on that? Okay.
Ready, Your
Let me take this one first. First National versus John E. Kovacs, 240424. Mr. Kovacs, you have to start your video, please.
Yes, sir. I was just trying. Sorry.
That's fine. Your name?
John Kovacs.
And Your Honor.
What
for
did
the
I
record,
do last time, counsel? I reinstated the case.
I don't think we did actually, Judge. I think we were waiting to see if the defendant would file bankruptcy. He had, again, Albert Kim, P70301, appearing on behalf of plaintiff. We appeared last, I believe, in earlier mid-year sometime. I can't remember the exact date, but defendant had a bankruptcy order where he was not permitted to file bankruptcy until November. He didn't do so, so we refiled our motion. He has since filed bankruptcy as of January 9th, so our matter is resolved.
So you're going to present an order staying the case, right?
Staying the case. I believe it's already stayed, Judge. I think this motion was to reinstate. I don't think we ever reinstate it or no?
Well, you filed a motion, I think.
And I think we decided to hold off on it just based on the fact that he expressed intent to refile. So I didn't want to come back here again. And of course, just took a little bit longer.
Wait a minute. I thought we were up for a motion to reinstate.
We were, Judge. And again,
So now he's filed bankruptcy, right?
Yes.
So you still need to file a motion, bankruptcy stay order, right?
I'll get one to the court then. Absolutely, Judge.
That's what we'll do. File your bankruptcy stay order, please. Thank you very much.
You have a great day and Happy New Year, Judge.
You too. Same to you guys. People against Peter Flash the fourth. 25F2726113. All right. Good morning, Ms. Ford. How are you? Okay. Sure, your name?
Peter Lockwood.
All right, go ahead. I'm sorry.
Gave us this opportunity to return because I tried to get a deviation report to Gary Bresnan. I had the wrong email. Eventually I did, thank you, as a result of the adjournment, get it to him. And he responded that he could get in a drug treatment court if we could get him in, and has to plead to the third. My client does not want to do it. He wants to waive the exam, and we'll file. Just to let you know, my client had to take a blood test because he said he was diabetic. So I think that we have some technical defenses that would probably be better off in the evidentiary. And it's been 20 years since he had his.
So they wouldn't give you the,
Because he has an automatic rule if you have more.
he has what?
Well, I guess it's his policy if you have 4.
Oh, he had 4,
It's 4.
but they were a long time ago, weren't they?
No, you remember well. The last one was 20 years ago.
Yeah. Well, I mean, the idea is to get people some help. I'm sorry that he wouldn't do that. I'd have loved to have had him. I'll go ahead and take the waiver. Calling the,
You just said whatever I think is best.
calling the prosecutor, will you, John?
I was going by my client, what he wanted.
Yeah. So that's what you want to do, Mr. Lash?
Was it program under you?
Not if there's a waiver.
No, if he entered the treatment court.
If he was doing it here, but they're not offering him that, right?
Yes, they did. In my opinion, they did.
I thought you said they didn't.
No, they offered him if he pled though.
Well, you said plead to OWI 3. I can't take a plea to OWI 3
I'm pretty sure, yeah. And then I could get him in the treatment.
in Detroit.
Yeah.
Yeah, so I'm just disappointed that they're not gonna do it here, but that's neither here nor there.
What, up to remain.
So, all right, let me just get the prosecutor in
You're
here.
the state prosecutor, right?
Yeah, Ms. Asmaro, right?
Right.
Just give me 1 second. All right, so sir, in the meantime, your lawyer is telling me that you wish to waive your right to an exam. Is that true? If you waive your right to an exam, you're waiving the requirement that they prove that the crime was committed and that you were the one who probably committed the crime of OWI 3, and you'll automatically be bound over for further proceedings to the circuit court. Do you understand that? Mrs. Morrow, your name?
Good morning, Your Honor. Not to me as on behalf of the people, BAA Corinth.
Good morning. Listen, you did a no objection to waiver form last time. I'm going to need you to do one today. You don't have any objection to waiver, correct? Can you write that up and send it in, please, real quick? So, sir, you understand everything that's going on here. You understand you're charged with a felony. If you waive your right to an exam, I'm sending you to Detroit for further proceedings. Anybody force you to give up your right to a preliminary exam? All right, counsel, can you write that up for me, please? I'll-
You would plead to a third year.
He can't plead to a third.
It downtown. Then if I found them.
Your Honor, we did this in Westland about 2 weeks ago. When I spoke to Gary Bresnahan, he's the APA who deals with all of our OWI thirds.
Right.
I did mention last time, he has a kind of a list of things that he looks for when giving offers for OWI thirds. One of them being it has to be a true third, because this was his work, he did automatically deny it. But he also did mention, and again, we did this on a case in Westland, he pleads to an OWI third in the district court, but he gets sentenced in circuit court, and then that's if the court allows him to come back and do some.
Just let him plead in circuit. Why would you not have him plead in circuit? I mean, it makes no sense to me. If he's gonna,
Come back for Supreme Court, but that's.
well, they can take it back. If they want to reduce it there, you can tell the judge, whoever it is, will be happy to entertain it, as long as I approve of the terms and conditions.
Thank you.
Okay, I'll be happy to take it. But I'm going to approve of the terms and conditions if there's a plea. So I don't want a circuit judge saying I got to give 120 days or, because I've gone over this on and on ad nauseum with the prosecutor's office. They want to say if they're, and I'm thinking that they're coming around. But I'm not going to take a plea if it says judge has to give a year if they're convicted of a crime, which would include expired license, improper plate, and silly things like fishing without a license. I'm not doing that. So if they want to conditionally send it back for my approval, I don't have a problem with that. Okay?
I understand, Your Honor, and the only reason we have that done as an OWI third in a different district court, Westland, was so that offer could stick with APA Gary Bresnahan, opposed to going down to our general trials where another prosecutor will be the one to make that decision. So
Well, if they pleaded to OWI 3 down there or here, I don't have any jurisdiction anymore. Right? How can I handle felony down there? I'm not a regional treatment court. No, I don't. I'm serious. There's regional treatment court in Taylor. I can't do that here. If it's pleading to an OWI 3, that's beyond our jurisdiction. If he's pleading to an OWI 2, that's within the framework of our jurisdiction.
I understand, Your Honor.
So, but I'm saying if they decide to plead to impaired 2 or OWI 2 and they want to remand and I approve of the terms and conditions of the sentence agreement, I don't have a problem taking it back. But I'm not taking it back if I don't approve of the terms and conditions. So they can figure out how they want to do it down there. Do you understand everything that's going on? You have a charge of operating while intoxicated third, which is a 5-year felony. Our jurisdiction only goes up to OWI 2. I could take the plea, have you go downtown, get sentenced there, but it makes no sense to me here. None, zero, zip. Go down, let your lawyer work it out with the prosecutor. They've got a treatment court down there. This just took too long, you guys, really. I mean, so if you guys want to, but I want to be clear, I'm not taking back a case on remand unless I agree to the terms and conditions of probation, however they want to do that. Okay? All right. So you understand that you're going to be bound over for further proceedings to the circuit court.
Yeah.
And you understand that's a 5-year felony. And you understand you're waiving the requirement that they show that the crime was committed and that you were the one who probably committed the crime. Anybody forced you to give up your right to a preliminary exam? All right, I'll accept the waiver. PR bond is continued. AOI date will be January 27th. I still need you to put a form in here saying no. You don't have any objection to waiver, right?
No,
Pardon?
no, Your Honor.
Okay, good enough. That's fine.
Would you like me to go right?
Nah, don't worry about it. As long as you state it on the record. Thank you.
Thank you for your patience. and-
No problem.
Thank you.
Good luck. Have a good day. Good luck to you, sir. I hope this works out. Gustavo Cesar Velazquez, 25B149, 56R. Come on up here, sir. Your name?
Gustavo Velasquez,
How you doing?
pretty good.
You're doing the right thing coming in. Thank you. You're one of the guys that actually takes me up on this. You need more time to pay?
Yeah,
How long?
just one more month and then I'll be able to come in and knock it out.
Time to pay extended until February the 15th of 26. You did the right thing coming in. February 16th, okay? Good luck.
Thank you. Have a good.
You too. Miller. Michael David Miller Jr., 26W729913. They ready on this? Good morning, Detective. Your name?
Detective Sergeant Robert Vespreme at the Woodhaven Police Department.
Raise your right hand. You solemnly swear affirm on penalties of perjury. The testimony you give in these proceedings should be the whole truth, so help you God.
I do.
Okay, go ahead.
Yeah, on November 9th, 2025, at approximately 0110 hours, Officer Nicholas Mitchell and Officer Kyle Emery were on patrol in fully marked unit, Woodhaven Unit 1212. Officers observed defendant Michael Miller traveling on King Road near I-75 in a black Ford F-150. Officers noticed that Mr. Miller was not maintaining his lane. Officers conducted.
It's not what? I'm having a little hard time hearing you real clearly. Can you get a little closer? I didn't hear that last sentence.
Yeah, can you hear me better now if I speak
A
up?
lot better.
Okay. Officers noticed that Mr. Miller was not maintaining his lane. Officers conducted a traffic stop and made contact with Mr. Miller. Officer Mitchell stated that he could detect the overwhelming odor of intoxicants coming from Mr. Miller's person. Mr. Miller was requested to do field sobriety evaluations, which he then attempted. Mr. Miller was then requested to perform a preliminary breath test, and he refused to do so. Officer Mitchell indicates that based on his evaluations of Mr. Miller, that he believed Mr. Miller was under the influence of alcohol. Mr. Miller was placed under arrest for operating under the influence. While at the police department, Officer Mitchell read verbatim the DI 177 to Mr. Miller and requested that he submit to a breath test. Mr. Miller refused by stating in quotes, no. A blood search warrant was completed and signed by Magistrate Giacomo from the 27th District Court. Mr. Miller was transported to Henry Ford Hospital where RN Jennifer Finley drew 2 10-milliliter vials of blood from Mr. Miller. Mr. Miller's blood was sent to MSP lab for analysis. On December 2nd, 2025, lab results indicate that Mr. Miller had 0.282 grams of alcohol per 100 milliliters blood. Should be noted, the defendant was previously convicted of operating impaired on August 25th, 1998 in the 36th District Court and operating under the influence of liquor on February 28th, 8th, 2002 in the 33rd District Court.
Based on your sworn testimony, I find the crime OWI 3 was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint warrant. I'll note that you signed the complaint. You dated it the 12th because it was sent over yesterday. I'm just changing the date and initialing the date change to the 13th. Is that it for you?
Yes, that'll be it, Your Honor. Thank you.
Have a great day. Thank you.
Yeah, you too. Bye now.
Farouk?
It's TCF Live on a Monday. Good morning once again, everybody. Let's switch it up. Let's say good morning to Judge Simpson.
What?
Do you want me to go in the hallway?
No, there's like a new judge next door, so everybody wants to see the new shiny thing, man.
We're here, Your Honor.
I know, you guys are ready? Well, thank you.
Say, yeah, you can go.
Get you guys out of here at least. Court does call the case of the People versus Dallas Williams.
I'm sorry. Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Dallas Williams. Please state your name.
Dallas Williams. All right. Ms. Williams, it's good to see you other than a little small box on my screen. All right, what are we doing?
Your Honor, we just need to plead impossibility at this point and then waive it over to the circuit court.
Not sure why you would have to do that, but so he's just doing a waiver.
Yes, Your Honor, there's a waiver in the file.
So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. As to the arraignment,
Waive formal reading, stand mute, Your Honor.
defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 11th at 1:30 before Judge Conlon.
March 11th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you.
Your Honor, before we close
Yes.
the record, I also spoke with defense counsel about having his client agree to move the bond payment over to child support arrears.
And
That we went through this and typically that is done at arraignment automatically, but let's see if this slipped through.
Your Honor, I just learned he posted bond last night, but we don't oppose the being applied to the
He
arrearage.
just posted bond last night.
I just
Right,
found
but
out.
the bond. Right, but the order that if he did should have been done at arraignment. Yes, and it on December 19th, 2025, there's an order from his arraignment that bond to be released to, and then it states the case number.
This happened January 2nd already to circuit court.
It already went over.
That did, yes.
So it's already gone over.
Correct.
All right. So we checked and that was the date of the order was in December, and then January 2nd, I'm informed, or something like that, it went over to circuit court from 15th District Court. Okay?
And I do believe the concern is my client has several child support cases. We want to make sure that that bond is applied to this child's case. There's only one current case active.
Only one what?
One current arrearage case that I was able to find in the city
For Washington.
for Washtenaw County. I don't know of any other counties currently.
So I can just tell you, now that I can find it again, the bond form clearly indicates that it is going to be paid over on case 2013-298 DP.
If there's any problems, I'll reach out to the DA's office and we'll rectify the city. Your Honor.
It is it's being paid over to the case that's in the complaint. So.
Perfect. Thank you, Your Honor.
Thank you.
All right. Thank you, folks.
Thank you.
What?
And also.
What do you mean we lost Elman? Okay, where are all the people? Well, not you guys. I see you. Where are all the attorneys?
Happy to go out on my way out and see where they're at. Right.
Yeah, when you go out and tell them I'm like really angry.
I'll tell them that you're giving out free kittens. They'll get them all the time.
Okay, that's a little weird. I say just tell them I'm angry. Free kittens. Hey, thinking of all the stuff I've done in my life, I've never given away free kittens. I don't know what he said. Well,
We were here a long time, but I'm in that room.
what do you mean we were here a long time?
Oh, she knows. They're there.
No, they said they've never seen you before. No. All right, but
I don't know where the prosecutor is with,
I have no idea. I've seen one prosecutor, and that's the Attorney General. I've not seen any Washington County prosecutors.
he was in here, Mr. Yeah, you were here early.
Oh, well, lo and behold.
It wasn't him, but the other one.
As we speak.
He's not my prosecutor.
Yeah.
I'm in the conference room though.
What?
So, I'm in the conference room with a client.
Okay, so you're not ready on your case?
Well, we're ready. He said he had to look to see if his people were here, the prosecutor, not this prosecutor. He had to look to see if his people were here, but we could come in.
Ms. Barnwell, who are you?
Blonde guy.
The blonde guy.
Sorry.
Who is it?
Mr. Cook.
Oh, Mr. Cook.
He's talking to someone in the conference room.
Okay.
I'll go grab what case?
Oh, no, I'll wait. You guys figure out what you need to do. Mr. Childers, you have anything ready?
I have, Mr. Kawan White is ready with Mr. Denowith. I don't see Mr. Denowith.
Yeah.
If you have Mr. Elmer.
I think I'm currently the only attorney in the courtroom, so.
I'm sorry?
If we have Mr. Elman.
Mr. Elman, yeah, we're ready on,
Ready on here.
on Perry, yes. I can probably get Mr. Elman.
Okay. He walked in and then. I need to start screaming and yelling. Then they'll all run in. Everybody will come in then.
Well, maybe they're all off seeing that shiny new judge he mentioned. But while they sort out where everybody is, let's go over to Judge DeSanto, say good morning to her.
If I'm here, if she's here, we've made an offer, I'll stand by the offer, even if he shows up later, it's picked up on a wolf. We waited 45 minutes, so.
I don't see so much of me.
And there are big time lawyers behind me waiting to move in.
Excuse me, Bob. Okay, well, hold on. We're on the record right now, Ms. Wuhan, so hold on. So you'll get a jab in after we're off the record. So, the court is going to issue a warrant if Mr. Williams does not appear in the 27th District Court by January 15th.
All hell will break loose, right?
Okay, and so the court will note that it will be a $5,000 10% bond that issues.
Thank you.
Okay,
And Judge, we'll keep the offer open in the event he shows.
go off the record.
Thank you.
Okay.
Thank you, Your Honor. Have a great day.
You too.
I will see you next time.
All right. Thank you.
I guess I gotta continue with the rest of my day. Great. Okay.
Well, this is probably your easiest one of the day.
Yeah, great. I'm gonna go to the office where everything's on fire.
Can I approach for 1 second?
Okay.
Bye, Ed.
Bye.
All right. Bye.
All right, she's muted. Let's go back to Judge Simpson. He found some people to talk to.
Cruz, Mena.
All right, we're ready to proceed, Your Honor.
All right.
This is the day and time set for preliminary examination, and since people are unable to proceed.
And Your Honor, given that the people are unable to proceed, we'd move to dismiss this case.
People being unable to proceed, this case dismissed on the. Hold, sir. I don't know who you are and why you're interrupting my proceedings. And why your phone is on also. Who are you?
Andrew Stevens, I'm a victim. I didn't check in. Your Honor, can we pass this matter?
Go back. Go back.
Thank you, Your Honor.
Sir, that is not the way that you conduct yourself in here. If you needed to get the prosecutor's attention, there's a way to do that, but interrupting what I'm saying is not going to be good for you. Understood? Thank you. That's it?
Yeah.
Well, now I have attorneys, but are they ready? Ms. Yagi, how are you?
Good morning, Your Honor. I'm doing well. How are you?
You're doing well. Are you guys ready on anything? No?
No, yeah, but hopefully very soon. I just have to talk to Mr. Cook very quickly. But we did talk this morning. We have to talk a second.
That's fine.
Thank you.
Mr. Cook has to talk on that case. So you have nothing else ready?
For right now, I don't know if the defense attorney is ready on Happen or Cantor, but I'm ready on that one.
Who's the defense counsel?
Lauren,
Who? Where's he? You want to know what? Why do I feel like I'm being ignored? That doesn't work well. Where are all the attorneys? I don't, with all due respect to those that are here, but where is Mr. Warren Green?
would you like me to check next door? Your Honor? He is next door. I just came from next door. I can go get him, Your Honor. Thank you.
It's going well. Should have stayed back. Should have stayed in bed. It showed up around noon.
So I got to be honest with you guys. I don't know that we've ever gone to Judge Simpson's court and seen it this chaotic, where there's like missing lawyers and nobody seems to know what's going on. And I'm surprised that he's not like throwing gavels at people at this point. So this is really weird. I don't know. Let me know what you think in the chat, but very bizarre.
Are you lost?
Oh.
You don't look happy. Why? I'm just looking to do something, but not everybody's cooperating.
I gotta go get the prosecutor. I'll warm something up.
Who are you going to go get? Is that something over here? Are you guys ready?
Pretty much. Just a little detail guy. I'll hurry up.
No, you won't. Yeah. Mm. It appears, Ms. Yagi, you were unsuccessful.
Your Honor, I was told that sworn screen cases be called next door. And so it's a very short matter. And so he'll be here with it.
Was he on the record?
He was not.
So he's telling me to wait.
Apparently.
Okay, well, court's gonna stand in recess.
All right.
Alrighty. I was waiting for him to at least quasi lose it and leave the bench, and there it is. Again, I've never seen a Judge Simpson court that chaotic. I mean, his dockets are normally pretty buttoned down, and he doesn't suffer much as far as fools go. But there we go. Let's go to Florida. Wade Mercer, first appearance.
Good morning, Mr. White. Your girlfriend and her parents are both in. All three of them are in the courtroom. You're here because you've been accused of a new charge of uttering a forced instrument. Mr. White, there is probable cause in the complaint. This allegedly occurred on December 5th, which was after you were on probation for a different uttering a forced instrument. So, Mr. White, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, and then we're going to listen to the state. Mr. McDaniel, anything on behalf of Mr. White?
No, Your Honor.
Mr. Mitchell.
We just request that a 7-day hold be put on him to decide whether or not probation is going to violate him.
Okay. Thank you. So, Mr. White, I'm going to set you a bond in a new case. I set a higher bond for people who are on probation. That bond's going to be $10,000 cash or surety. You have a condition of no contact with the alleged victim, but don't try to post the bond. The reason I'm telling you don't try to post the bond is you've got no bond for 7 days. Mr. McDaniel, you want to say something?
He's already been violated on his probation, so maybe if the court wants to go ahead and serve him or let him, we'll give him a court date on it. I'm not sure.
Because of there's a warrant out, or what do you mean he's already been violated?
There's a warrant out.
There's an active warrant. They just didn't bring it.
He turned himself in. So it is, I know, but it's all right.
Okay, so there's no warrant in my packet. So, Sarge, y'all don't have a warrant.
Yeah.
Right. They didn't bring it. I just seen it this morning on CCIS when I was in here.
Okay. So in the system, when you haven't been served with it yet, there is a violation of probation warrant. So Sergeant Applewhite, I'm going to ask you to contact the sheriff's department and tell them that when they arrested him yesterday, they served one warrant and didn't serve one. So he's at the jail and we need to get this VOP warrant served on him. So there is already a violation of probation warrant, and I'm looking at it now, and it's based solely on the new charge. And the judge in that case, which is Judge Garcia, has issued no bond in the VOP. So I'm going to go ahead and first appear you on that also. You're accused of violating your probation, and I'm going to go ahead and get you arraigned on that. And the reason we're doing that is I want to get you an attorney appointed and get that case moving. So even though it hasn't been served on you, that hopefully that's going to happen today. We're going to go ahead and first appear you for that. Would you like to have an attorney appointed to represent you in the VOP?
Yes, sir.
All right. I'm going to appoint an attorney to represent you in the violation of probation. So I'm going to ask that you listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
We're going to have to not guilty. He has to set this on the next docket, which would be February 5th, or it may be February 2nd, because his other case will be on February 2nd. I've advised him that one of the public defenders will come out and visit him. It'll probably be someone assigned to his new case that'll talk to him about the violation of state probation, but they'll talk to him about it before that court hearing, or it may be at that court hearing on February 2nd.
So February the 3rd. February 3rd will be your court date, and that's on the arraignment docket.
Yes.
February 3rd at 8:30. So it gets a little confusing. Mr. Guy Green is the assistant public defender that does violation of probations, but he does not do them usually if there's a new felony. Whichever attorney gets the new felony usually has a new felony and the VOP. So I don't know if it'll be Mr. Green, but more than likely it'll be a different assistant public defender. Whoever has him on the new charge will probably handle the VOP also. So your court date's going to be February 3rd. You've got no bond, at least for the time being, and the public defender's office has been appointed to represent you. Mr. White, do you have any questions?
Not at this time.
Does the family or friends have any questions?
There's another charge?
There's two charges. One is the new charge. One is a violation of probation based on the new charge. It's just one new charge, but there's a VOP. So he's got a bond in one, but there's no point in posting it because he's got no bond in the violation of probation. That no bond is set by the judge in that case. And actually, both cases will go before the same judge. Judge Garcia will have both cases. Any other questions?
What was that bond?
I set up a bond of 10 on the new charge, but he's got no bond on the VOP. Wish you the best, Mr. White.
I got this.
Thank y'all for coming. That's it for friends or family, so we can go back to the top of the list. The first case on the docket is Timothy Collette. Mr. Collette, come on up. Mr. Collette, you're here in case number 25-578MM. You're accused of violating the terms of your probation by leaving an inpatient drug treatment center. Mr. Collette, I'm going to appoint the public defender's officer to represent you. And I do have a text, Mr. Mitchell, and I'm not sure if y'all are included on this or not. Sergeant Gross sent me a text. Mr. Collette's positive for THC. And Mr. White was negative for anything illegal. Okay. So, Mr. Collette, listen to Mr. McDaniel. We'll see where we go this morning. Mr. McDaniel.
Your Honor, we're going to admit that we violated county probation. Yes, 21 days jail credit, and just ask the court to sentence him.
21 days. All right. So, Mr. Collette, I need to explain to you a couple of things. Mr. Collette, you're accused of violating the terms of your county probation on a first-degree misdemeanor. Mr. Collette, you have the right to go to a hearing in this case. If you go to a hearing in this case, the state will try to prove that you violated your probation. Mr. McDaniel will be representing you to try to present any defenses you may have. That I would make a decision, or whatever judge hears the case, probably would be me, would make a decision of whether or not that's proven. On the other hand, you have the right to waive that right to a hearing and enter a plea and admit you violated your probation. If you waive the right to a hearing, you're also waiving your right to call and cross-examine witnesses at the hearing. There will not be a hearing if you waive it. I will listen to you. I'll listen to the state. I'll look at the file, and then I will impose a sentence I think is appropriate. Mr. Collette, knowing all of this, do you want to waive your right to a VOP hearing and admit you violated your probation?
Yeah. Yes, sir.
All right. I'm going to accept your admission. I'm going to find it Nolan voluntarily entered with the advice of counsel. So, Mr. Collette, let me go over what the report says, and then I'm going to be glad to listen to you. So what you're accused of doing is, according to this file, last month, you were sentenced on December the 19th to 11 months and 29 days probation. The charge was first-degree misdemeanor criminal mischief. You were allowed to go to CREMO and serve your sentence at CREMO. CREMO Inpatient Drug Treatment Center, and as long as you completed that probation, that sentence there, that would satisfy your jail sentence. So if you completed CREMO, you were not to do any jail time, that sentence would be it. I'm not sure what day you went to CREMO. Mr. Goodson may know. But according to CREMO, you left on July 11th. January 11th, I'm sorry. Can you, I don't know if he can hear you, Mr. Goodson. Can you get in front of a microphone so he can hear you, please?
He got put on probation he was instructed on December 19th. Correct me if I'm wrong, John. I think he went that afternoon. Did he not?
I'm assuming he went up that afternoon. He went that same day. That's my calculations were on that day.
Yes, sir. So he got put on probation on December 19th. My understanding is he went to CREMO on December 19th that afternoon. We received a letter, an email from Julie Jenkins yesterday alleging that on Sunday morning, Mr. Collette just walked out of the facility without any explanation. He called me yesterday morning. I told him there'd be a warrant issued for his arrest because he failed to remain on incomplete treatment. His mother called yesterday afternoon and said she was going to bring him to our office. I told her just take him to the sheriff's department and turn himself in.
Okay. So he stayed about 3 weeks, if my math is correct. So, Mr. Collette, that's what you're accused of. If anything you want to tell me or anything you think I need to know, I'm glad to listen. Or Mr. McDaniel, whoever.
I was just going to ask for one more chance at CREMO.
Yeah, that's not going to happen. Any other request? I'm not going to let you go back to CREMO. I let you go. You stayed 3 weeks and you left. I don't know that I've ever let someone go back. And I'm not going to let you go back there. I think there's a limited number of beds. We need those for people that want to be there. And all right, you had your shot. So I do appreciate you turning yourself in the same day or the next day after you left. I'm not sure which.
call. I received a letter from Chrome.
He turned himself in Monday. Okay, so it was the next day, and I appreciate that. It's not like you were gone. I had one yesterday. That gentleman was gone 7 months. So I am going to take that into account, and I'm going to take, that's going to show in your sentencing. The other thing I appreciate is you only had THC in your system. Had you had methamphetamine in your system, that would be something I would want to know. But so I'm aware of that. But the chance of me letting you go back there after this is it's just not going to happen. But if there's something else you want to tell me or ask, I'm glad to listen, Mr. Collette.
No, sir.
Mr. McDaniel, anything on behalf of Mr. Collette?
No,
Anything else? Mr. Mitchell?
I think you said pretty much everything, Your Honor.
Mr. Collette, your sentence was, your original offer was 6 months in jail, but I'm not going to sentence you to something that would let you do less time than you would have done in Chrome. Chrome would have been 6 months inpatient, I believe, perhaps 9 months. I'm not sure. Yeah. Okay. So what I'm going to do, Mr. Collette, is I'm going to sentence you to 9 months in jail. I'm not going to sentence you to the full 11 months, 29 days that you were offered this morning, because I think you should be rewarded for turning yourself in. And I'm also appreciate the fact that you did not have methamphetamine or something like that in your system this morning when the jail tested you. So I'm going to sentence you to 9 months in jail. You do have credit for the time that you served. And Mr. McDaniel, that was 20, how many days?
21 days.
21 days. Any court costs and fines that remain unpaid, which are probably all of them.
370.
370 court costs and fines. You'll get a chance to work off those. And Mr. Collette, because we started doing these on probation now, you are better off than under the old system. Under the old system, you were sentenced to jail, and leaving would have been breaking a jail rule. Under the new system, this is a probation violation. So you haven't broken a jail rule. So as far as I know, you still may be eligible for both state and county gain time, which could be up to 10 days a month off of your sentence for good behavior. So talk to the jail about the trustee program. But there's no probation involved in the sentence. And this is the first court date you've had that your mother hasn't been here. I don't know if she wasn't aware you were coming up, or she's just unavailable this morning. But if she calls our office, we'll let her know what the sentence was. Mr. Collette, I do wish you the best. Do you have any questions, sir?
No, sir.
Wish you the best, sir.
Yes, sir.
Next case is Carrie Walk. Ms. Walk, good morning. Ms. Walk, you're here for first appearance, ma'am, accused of one count of possession of methamphetamine and one count of possession of drug paraphernalia. Ms. Walk, there is probable cause for both these charges. I've looked at your criminal history, ma'am. It appears to me that I'm aware that according to the Department of Corrections website, you've been to prison 3 times. So I'm aware of that. But I think you're entitled to a bond as far as I can tell. So I'm going to see if the attorneys have any additional information, and then we're going to address that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
We just request you be subject to random UAs.
Ms. Walk, I'm going to set you a bond of $7,500 on the felony, $3,500 on the misdemeanor. Your total bond is $11,000. It's cash or surety. That's important, ma'am, because surety means you can go through a bondsman. You do not have to come up with all that money. And ma'am, you do have a condition of random urinalysis. So if myself or Judge Garcia or any judge in your case drug test you or ask that you be drug tested, then a positive result without a prescription could result in a violation of revocation of that bond. Ms. Walk, you will get to use the phone in just a few minutes, ma'am, to try to post the bond. The jail is also going to give you a notice for your court date. Your court date will be February the 3rd at 8:30 a.m. and they'll give you that notice. Ms. Walk, do you have any questions?
No, sir.
Have a good day, ma'am. Deontay Bellamy is next. Mr. Bellamy, good morning. Mr. Bellamy, you're here for first appearance accused of one count of trespassing. Mr. Bellamy, there is probable cause in the complaint in your case. And I looked at your criminal history in, I think, 3 different states. So I'm familiar with that somewhat. Mr. Bellamy, I'm appointing the public defender's office to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, we just asked for a reasonable bond.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Bellamy, given your criminal history, I'm going to set your bond at $5,000 cash or surety. You have a condition, have no contact with that property at all. You cannot go back to that property for any reason that you're accused of trespassing at. We're also going to give you a notice for your court date. Would that be the 2nd? February 2nd at 9 a.m. will be your court date, Mr. Bellamy, and they'll give you that notice in just a moment. Mr. Bellamy, you'll get to use the phone shortly to try to post the bond. Just don't go back over there where they're accusing you of going. Mr. Bellamy, do you have any questions?
No, sir, not right now.
All right. Wish you the best, sir. After Mr. Bellamy, the last case for the morning, I think, is Blake Larkham. Mr. Larkham, good morning. You're here because you've been accused of one count of petty theft. Mr. Larkham, there is probable cause for the charge. I'm going to appoint the public defender's officer to represent you, Mr. Larkham. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I've spoken to Mr. Larkham. He's going to accept the PTI for 6 months. Restitution not to exceed $16.75. And there'll be a $370 fine. And he can only terminate after 3 months. If he gets everything completed, takes a retail theft class, and does everything he's supposed to do.
Mr. Mitchell's had agreeable with the state.
It is, Your Honor. Was that an added condition of the retail theft count?
He did. He did put that in there. Mr. Larkham, is the address on Penn Avenue, is that your correct address?
It's one of my addresses, sir.
Okay, that you have to give one address to the probation office. Is that where you're normally at? Is that where you get mail at?
Yes, sir.
It's just unusual to see a Penn Avenue address and a I think it's a Dollar General in Sneeds is the alleged
Where you want your mail to go?
Sneeze.
well, it just says
I would like my mail to go to the Penn Avenue address.
okay, all right, the Family Dollar in Sneeds. It's just unusual, so I didn't know if that was a typo. Yeah, there's going to be no contact with Family Dollar. So, Mr. Larkham, you need to understand if you enter this PTI agreement, part of that PTI is a no contact with any Family Dollar while this case is pending, and it's technically pending while you're under the supervision. The other thing you got to understand is part of this PTI is a conditional release, so that means it kind of gives some teeth to that program. If you don't report in like you're supposed to, if you commit a new crime or charged with a new crime, if you have contact with Family Dollar, then you could go to jail without a bond. So you have to take it seriously. Mr. Larkham, the good news is if you do what you're supposed to do and stay out of trouble, then this case against you is going to be dismissed. You follow all the rules of the PTI, it'll be dismissed. Mr. Larkham, do you have any questions about the PTI agreement?
No, sir.
And you do want to participate in the PTI, right?
Yes, sir.
I'm going to show you a case referred to the PTI program for the terms and conditions Mr. Mitchell and Mr. McDaniel and myself placed on the record. Mr. Larkham, that's 6 months, possible dismissal after 3 months if you get everything done. If you need the full 6 months, that's okay too. Mr. Larkham, what's going to happen next is the jail's going to let you use the phone for transportation purposes if you want to. Then they're going to let you get dressed in your regular clothes, Mr. Larkham, and then they're going to bring you to the courthouse because that's where the PTI office is at. It's the same as the probation office. When you get here, Mr. Goodson or Mr. Ham, one of the PTI officers, will go over the PTI with you. They'll answer any questions you have about the PTI. They'll give you a copy of all the rules in writing, and then you'll be free to leave. Mr. Larkham, do you have any questions you want to ask me about the disposition?
When will this happen? I go to the courthouse.
Probably about 30 or 45 minutes from now.
Okay, yes, sir.
All right, wish you the best.
Thank you.
Yes, Stacy, would you give him some information maybe on workforce development? The old unemployment office, we look for jobs, he can find something to do. If you don't mind, I just was thinking back in my head after I talked to him.
Seemed like I heard this morning somebody looking for somebody, employee. I can't remember. Mr. McDaniel, Mr. Mitchell, I do have one thing on scheduling. So my sister has a medical procedure next Tuesday, the day after Martin Luther King Jr.
All right. Well, I wish his sister well, but I don't know that we need to hear that full story. So we were asking about Judge Boyd earlier. She has just opened up her court, so we'll keep an eye there. I also have eyes on Judge Simpson. He is still in chambers. maybe having a stiff drink or something, the way his morning started. Let's go back up to Michigan though, and there's my mouse. Let's see what's going on with Judge Oakley.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? All right, come on up here. There's a ramp right here. Don't trip. You're going to take that chair right there. All right, Ms. Evans, have a seat there. Settle in. When you're ready, counsel.
And good morning, Ms. Evans. Can you please spell your name for the record?
Janae Evans, N-J-A-N, I-A-E, Evans, E-D-A-N-S.
Thank you, Ms. Evans. Now, were you present at a 35012 Michelle Drive in Romulus, Michigan on October 10th, 2025? Okay, and what is that residence? And were you there with someone else on that day? Who? And does Danny have a last name?
Yeah.
Oh. Now, who is Danny related to?
Say that again. I'm sorry.
Dating at the time?
Thank you.
So if you could, I know this is microphone, you gotta be with right up to it, so if you want to adjust it, you do so. Feel free.
That better?
A little right,
That better?
a little closer. Okay. There you go. You got that?
Yeah, thank you. Okay.
So, ex-boyfriend dating, fair to say you could point him out if you had to. All right, so is he here at the court today?
He is in a gray jacket.
At this time, and ask the record identified?
Noted.
All right, so you were there with Mr. Adams that day. Were you there, early in the morning of that day? Did anything happen? How did he work here?
Yes, he woke up angry. Taking a fight at me. He jumped on top of me, but it like came against my face. It was his back at me.
All right, I'm just gonna stop you there for a minute. So you said, put your hand up to you and you gestured,
He was on this, like push my face, so I lay on my bed. He was beside me. And he put his hand on my face, pushed my face up against the wall, and he was fist back up. He was gonna hit me.
and just for the record, to reflect, witness grabbed her left hand, put her thumb on one jaw and her index finger on the other jaw, lifted it up, till her head was stretched back, and then balled her other fist, about 90 degrees, upward.
Noted.
After that, did anything, did he say anything at that time?
We were just arguing about it, but the details of arguments were, the fight began, essentially, technically the night before, doing that, my daughter told me to stop, that she just wanted. So it started off that night, went to bed angry, woke up still angry, just that was before the nonsense. And then it escalates where he put his hands on me. And then I got up, I was like, I'm getting ready for work, I'm gonna get home, you know? At that time, we said, ready, I was like, you go here, I'm going to Australia, I'm getting home, I'm getting back to see what you say. Okay, that's fine.
But his statement?
No, she's testifying to her own statement. Which is not a court statement, all for the truth of the matter is there of what she said.
Okay,
So. You recall saying those things? Correct?
yes, correct.
So going ahead, after this physical altercation, you said you went your separate ways, correct?
So I was getting ready for work, that's what I was doing. I was getting ready for work. And I had been, and taking care of my mother. So getting to work, taking care of my mom, announced my kitchen area. And I could see out the open window where my daughter was going to talk her. It's coming back into my driveway.
Okay. And did you see a driver?
Yes, I can I went to my front door, open up. I mean, open my.
So let me just clarify. So you're outside right now?
No, I'm inside looking out. So when I look out, I walk out, open my door, and then I'm outside. My side door.
So now you're outside your side door and you see. What do you see?
Yeah, I think, you know, my daughter's boiling car. He throws the keys at me I got his little keys and walks down to my car, which is now parked on the side of the road in the house.
So your car is parked on the side of the road in front of your,
Yes.
and what happens next?
He asked me, am I hungry? Like, let me please put my car back in the driveway. And he's, I'm gonna object to that. Okay, well, I asked him to put my car back in.
Hold on.
Oh,
No, I can answer it. You just can't. So Judge, I don't know if it's. Her statement, she can testify to what she said in the moment. I don't think it's hearsay.
Overrule the objection, move on.
So going forward. What are?
Oh, he hopped my car. He asked me if I was ready. I told him to put my car back in my driveway. I was like, I need to put my car back in my driveway. If you don't, I did say I will call the police. And then he said, what are you gonna be able to do if you got sister? Call the police. He said, nothing's gonna happen to me because I never been in trouble, essentially. And he took off my car. I called the one, where we're at now.
Alright, so he drove off in what vehicle?
My 2019 Jeep Cherokee.
Okay, and is that his name?
Did not.
Does he have keys to that? Have keys, have you ever given him, or I'm sorry, have you given him a set of keys for that? He's never made a, did I already ask, has he ever made a payment for that vehicle? And did you give permission to use that vehicle?
I did not.
Judge, I don't think I have anything further.
Ms. Khan, questions for Ms. Evans?
Good morning. Good morning. I'm gonna ask you some questions. If you don't understand the question, I need you to rephrase it. Let me know and I'll do my best. No problem. At the time of the incident, you and Mr. Adams were dating.
Correct.
Mr. Adams spent a lot of time at your house.
Good.
You would occasionally spend the night.
Good.
You would go back between your house and his cousin's.
Correct. Or his mother's house.
Oh, or his mother's house. Thank you. And when you would stay at your house, you would stay in your bedroom.
Correct.
And you had a physical relationship.
Correct.
And Mr. Adams, and you, on direct indicated that there had been some fight related to your daughter the day before, correct?
Correct.
Did your daughter live with you?
She did.
How old is she?
She is 26.
Who else lives in the house?
My daughter, her boyfriend, and my elderly mother.
Mr. Adams does not have his own car.
He does not.
But he's previously used your car.
Yes, he has.
He's run errands.
He has, yes.
He sometimes would use your car to go grab his personal effects from his cousins or mom's house.
He has done that, yes.
And in fact, he used your car the day before you called the police. Correct?
And I don't remember.
Yes. Let's see.
I don't remember the day before. I take that back. I drove my car. I took him to his mom's house to pick up his things. I drove.
All right. And what day was that?
I think that was the day before. That would have been that day before, the day before that. It was between that day and the day before that. Can't remember that.
Okay, that's okay. How many times would you say that Mr. Adams had driven your car on his previously?
A handful of times. He's driven, because he did help me with my mom before. So he took me to work and went back and got my mom to, do things for my mother. Yeah, so it's been a handful of times where I gave him permission and said yes.
Okay. And the length of you and Mr. Adams' permission, relationship was about 2 months.
Correct.
And at the time of the incident, when you called the police, you were under the influence
No,
of marijuana?
no.
You talked. You gave a victim statement to the police, the Romulus Police Department. Okay. And would you recognize that statement if you saw it?
I would.
Commissioner GROFF?
Sure.
Ms. Evans, can you tell me what it says at the top?
Domestic violence incident, negative statement.
And I was pointing, that's your name there.
That is correct.
And that is your signature at the bottom?
That's correct.
And that was signed on 10/10/25.
That is correct.
And that's the date of the incident.
Yes, it is.
Okay. And under the check marks, were drugs and alcohol involved? There's a check mark on the yes box.
Yeah, but not me. I wasn't saying me.
Okay. Were you saying that Mr. Adams is under this?
That's correct.
No.
I didn't get very.
Ms. Evans, you can step down. Any other witnesses from the people? Any defense witnesses? Ready for argument? Watch your step on the ramp, Ms. Evans. Thank you.
Your Honor, I would, well, I would. wait. Your Honor, at this time, I believe it's a question of fact.
I agree. I'm going to bind over. AOI date will be 2 weeks from today, which would be 27th, 9 a.m. I will continue bond. And Mr. Adams, I wish you luck downtown. Correct.
Thank you, Jeff.
You're welcome.
We'll try to get.
Okay.
Okay, Ashley. So Horderman is today. I haven't seen him, but I'll go see if I can track him down. In the meantime, let's go back to Judge Simpson. He is back on the bench.
Court does call the case People versus Connor Rice.
Thank you, Your Honor. Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
Ron Brown appearing on behalf of Mr. Rice. Good morning, Your Honor.
Good morning, sir. Your name?
Connor Rice.
Thank you.
Your Honor, today set for a preliminary exam. We are going to, at this time, dismiss counts 1 and 2 and have the case remanded to 14B on count 3 for domestic violence. There's an agreement to do 4A. But I do have one ask regarding bond conditions.
No objection to the dismissal of the felony counts.
And then it's going to be remanded for a pretrial?
Yes, Your Honor.
Or
Pretrial before Judge Washington.
what it'll do is counts 1 and 2 are dismissed. I'll continue the defendant's not guilty plea as to count 3. A pre-sentence or pretrial will be set
February 2nd at 9 a.m. before Judge Washington.
February 2nd, 2026, 9 a.m.
Yes.
9 a.m. before Judge Washington.
Your Honor,
Yes,
when you're done writing,
I can do 2 things at once.
we'd ask the court to consider a consensual contact between Mr. Rice and his wife.
People's position.
Ms. Rice would like at this that accepts the consensual contact, so she would request that she have text contact with Mr. Rice regarding childcare. They have 3 children together.
Is there, and is that the same that you're requesting, Mr. Brown?
I was requesting that he go home. He was away for the holidays and have consensual.
Okay, I understand that, but she's not requesting that.
No, she's requesting just text contact at this moment, and then we'll visit a pre-trial.
Is there any type of family or circuit court matter pending?
I'm sorry?
Is there a family matter or circuit court matter pending?
No circuit court matter pending. He has no objection to text contact only at this time.
I'll be talking to my wife.
We'll talk to her about childcare on text. For now, if the judge agrees and modifies your bond. Text only about childcare issues.
Is there any way to get that or no? Yes, I'm live. Okay.
That's what the prosecutor said.
So what I will do is this, just regarding childcare, or is it regarding?
It's just a kid's yard.
Who pays the bill? I did. Your Honor,
Yes.
it's my information that my client pays a majority of the bills also. So I just wanted the court to be aware that there may be at times issues involving bills.
Involving what?
Finances, household finances. He's the sole breadwinner.
I'm not, so that's when it goes into all kinds of contact.
Then we'll stay with the
I'm just
childcare.
gonna have it regarding childcare. I'm not allowing any other type of contact. Do you understand that?
Yes, sir.
And this is a non-consensual contact, meaning if there's communication regarding childcare, that's not carte blanche. If she no longer wants communication with you, you need to stop. Understood?
Understood.
All right, I will make that change. And all other aspects, Bob, will continue.
Thank you.
Thank you.
Case People versus Kawan White.
Can I go grab Mr. Childers?
I can hear it. All right.
Yes.
Find Your Lawyer today continues in Judge Simpson's court. This is going to be interesting if it continues. He was in a great mood. Now he's frowning. I'm waiting for a blow up against somebody. I don't know about you guys. Let me know what you think in the chat, but this doesn't bode well.
No. That's Mr. Gilson.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Dunaway for Mr. White, who stands to my right. Sir, would you state your name for the record, please?
K1 White.
Thank you.
Your Honor, counsel and I approach very briefly.
You may.
All right, hopefully there'll just be a moment, so we'll wait it out for a second. While we're waiting, reminder, we have added a 4th hour to this show, although today it's going to be a half hour. We have a doctor's appointment we have to go to, so I have to cut it just a little bit short and only do a half hour during the last segment of the show. Do me a favor, if you're new out there, feel free to say hi in the chat, like, subscribe, do all that kind of stuff. Tonight, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Be joined tonight by Ashley and Austin and Michael. And I believe we're going to talk about when it would be appropriate to set aside the rules and consider compassion. This is based upon that Judge Elmore case we watched the other day, where the gentleman was sentenced for trafficking amounts of cocaine, but he was also terminally ill. So we'll be discussing that whole concept tonight. All right, it looks like they're going to be at this for a while. Let's go back to Judge DeSanto.
Two leads. Counsel, your appearance, please.
Good morning again, Your Honor. Jen Wilburn, P83143 for plaintiff.
Okay, and Ms. Correa, your name for the record, please.
Wendy Correa.
All right, and counsel, you had an opportunity to speak to Ms. Correa in a breakout room, correct? You're muted, Ms. Wilburn.
Sorry about that, Judge. That is correct. There's no dispute as to the amount owed. Ms. Correa has indicated she's applied for rental assistance. I did advise proof would need to be provided to the court within 5 days via the DC 539 form.
Okay, and ma'am, when did you file for rental assistance?
Department of Health and Human Services.
No, when did you do that?
So they won't help me until I get something from after going to court. So I have to do it today.
Okay, well, actually, they're incorrect in that, quite frankly. I know they won't tell you that, but they only need a summons and a complaint. They don't need a judgment or otherwise. However, the court will adjourn this for 14 days. You have 5 days to submit that form, ma'am, DC 539.
Is it D like dog?
D is, yes, D like DC, District Court, Form 539. And then counsel, we can put this to, looks like January 27th.
That works, Judge. What time?
Let's do 9 a.m.
So I have a question. January 27th, I just started a new job and I'm supposed to be in Southfield for orientation at 7:30 in the morning. Can we do a different day?
We could do Friday, January 30th at 8:30 a.m.
Okay.
Does that work for you, counsel?
January 30th at 8:30?
Yes.
That works.
Okay. Does it show we have a jury trial that day? Oh, okay, we always double check the jury trial, things after the, in chambers we've had to see if, some of those are still going. Okay, we'll see you all back January 30th at 8:30 a.m.
Thank you.
Judge.
All right, this day wins a little bit of the Weird Day Award. So Judge Simpson got out of his sidebar there and then immediately cut his stream. So, and just ended it. So I don't know what's going on in that court, but it's bizarre. Let's go over to Judge McNally.
Young, your name?
Michael Young.
Detective, your name?
Detective Corporal Sean Shapaniak, Trenton Police Department.
All right, this is a malicious destruction of personal property, 1,000 or more, but less than 20,000. It is a felony. Counsel, for purposes of arraignment?
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right, I'm going to enter a not guilty plea. Sir, I'm going to advise you of your rights. You do have the right to remain silent. You do not have to say anything. You're charged with a 5-year felony here. If you do say something in court or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir. Yes.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford a lawyer, I will appoint a lawyer for you at public expense. Also, if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
All right. Would you like an attorney to represent you?
I'll hire one. I'll get one.
How about if we do this? Sometimes lawyers on felonies are more expensive than people imagine. So how about if I have you fill out a petition for a court-appointed lawyer? And if you go out and hire one, and I would encourage you to do that, then in that event, I will discharge your, we will discharge your court-appointed lawyer, and your lawyer can substitute in the place and stead of the court-appointed lawyer. Is that fair?
Yeah, that's fair.
You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, if it goes that far, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
I understand.
You punch holes in this, please. Right where they are. All right. So I'm going to listen, Mr. Westmoreland, to whatever it is that you'd like to say.
Yes, Your Honor. Mr. Young currently is residing in Woodhaven. He is gainfully employed at Ford Motor Company, where he's been working for over 25 years. He's not currently on probation or parole. However, he does have a matter out of Wyandotte. It's a misdemeanor charge. He's on bond with a tether. In addition, he did have court yesterday. Judge DeSanto ordered him to be placed on a tether. He went down to Wayne County to obtain that tether, and that's where he was told that he had this warrant. He was not aware of this warrant, but after speaking with him, he did assure me he would be appearing at all future court dates, has no history of not appearing. Simply, he just wasn't aware of this one, but he does understand the importance of doing so. So I just asked that all that be taken into account when assessing a bond.
Detective, I did the signing on record on this back in July. Tell me what happened.
We sent a letter to his last known address that we had for him from the victim's information, and a letter was sent to him advising him.
I want to know, was he intoxicated? What is the relationship between he and the victim, and what did he specifically do?
He damaged her vehicle. It was a former dating relationship.
What did he do? Bash it in with all that or what?
He broke her windshield wipers off, and I also believe one of her side mirrors.
Has he been printed?
Yes.
He has?
Yes.
What kind of criminal history does he have?
One second, Judge, stand by. I just came back here. I don't have the CCH paperwork with us.
What's the charge he's in front of Judge DeSanto on?
I believe it's a disorderly person.
Which plant do you work at, sir?
Livonia Transmission.
Do you own the house on Chipmunk?
No, it's my parents' house.
Do you live with them?
Yes, yes.
Any kids? Married?
I have a 24-year-old daughter, not married.
Okay. How
Your
much
Honor,
do you
the only
make?
previous
Go ahead.
conviction on his record, his CCH, is an assault with a dangerous weapon back in 2001.
How much, money do you make weekly?
40 hours, 1250-ish.
7,500, 10%. You cannot leave the state without the consent of the court. I'm not going to require a GPS on this case. You cannot violate a law. You must appear in court as directed. Absolutely no contact with Monica Lewandowski. No contact with prosecution witnesses except through your lawyer. You're not to enter the property address at 1505 Harbor Boulevard in the city of Trenton. Also, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You understand all of that?
I understand.
Probable cause conference will be January 27th at 9:30. Preliminary exam February 3rd at 11 a.m. You'll be in front of Judge Hessen on those. I wish you well. And make sure he fills out a petition if you would, Detective.
Thank you, Your Honor.
Anything else, gentlemen?
Not this time, Judge. Thank you.
Mr. Geez. Mr. Young, any questions?
No, I'm all set.
Detective, anything else?
No, Your Honor, thank you.
Okay. Judge Simpson now back online. I'm going back there just because it's been so weird. I'm curious to see what's next. This court is so weird, Zoom doesn't even know what to do as it skips from camera to camera every second. This is just bizarre. I'm like 30 seconds or so in the Wayback Machine. Let's see if we can bump this forward slightly. Oh, no, here we go. But the court has no audio. That is not me. That is their feed. This is the most bizarre day I think we have ever seen out of Judge Simpson's court. I don't know what to make of it. Let's go back to Judge McNally.
I can resolve this today.
Yes. I just wanted to comment that.
You can comment on that next time. Let me just adjourn it a month. Plaintiff to get contractor bid, and we'll go from there. Can you give me a date in February?
Yes, Your
Jennifer?
Honor. We can do February 24th.
No, I don't need to go that far. We're
That
not
far?
going-
Okay, then 10th.
February 10th. And that'll be at what time?
I'm looking here. That would be at 10.
All right. And if you have pictures, you're going to give me an estimate as to how much you think you still have to complete. Okay, fair enough? And you're going to give me a breakdown, both of them, as to how much. Let me just double check something here. I mean, if you agree you didn't do the kid's bathroom at all, right? So he didn't.
You didn't get to start, so.
All right, we'll see you guys back on that day. Okay? Bring any witnesses you want, but I need that estimate from a contractor, and I want him to be present.
Yes.
He can be present on Zoom. I don't have a problem with that, if he's busy or she's busy, whoever it is, all right?
All right.
Thank you both, gentlemen. We'll see you in 3 weeks or so. Good luck. American Express versus Robert Johnson Jr., 2502605.
Your Honor, the attorneys are in a breakout room.
LVNV versus Dawn.
All right, I think Judge Simpson has figured things out now, maybe? Yay.
Location track.
Thank you.
Court does call the case of People versus Amari Harris.
Morning, Your Honor. Raymond Cook for the people.
Wasn't smart, she was just here.
Lucia just stepped out. I can go grab her.
Thank you.
Ms. Barnwell.
Yeah. Wait. Your appearance, please.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Amari Sanders.
All right, what are we doing?
We reached a waiver resolution on this matter. My understanding is that the defendant is going to be waiving on both files with the agreement on the file ending in 2162. There will be an offer extended in circuit court to plead to an added count 4 of unarmed robbery under FIDO, counts 1 through 3 to be dismissed upon taking that plea. And then on the CCW file ending in 2157, going to be a waiver up and a plea as charged under FIDO on that file.
Is that a correct statement?
That is true, Judge. I did communicate that to my client. He knows that the prosecutor is making a record today of the offer that will be available in circuit court. He understands that all his trial rights are still preserved, and he's willing to waive the exam, Judge.
Sir, you understand that you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution of both of these cases?
Yes.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 felony counts. Ms. Barnwell, your client waives formal reading, stands mute.
Yes, Judge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial in these matters will be set
January 27th at 1:30.
January 27, 2025, 1:30 before Judge Conkey.
Thank you, Judge.
Thank you. Yes.
Oh, wait. Oh. It looks like she. Barnwell.
Ms. Barnwell, were you ready on the Robinson matter?
I am here on the Robinson matter, Judge.
I know. Are you ready on that yet?
I am. I was having him sign the waiver.
Oh, okay.
I need information on the previous case.
On which one?
The previous case.
I will buy it.
Oh,
You have them? Court does call the case of the people versus Malik Robbins.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Malik Robinson.
Your name, sir? Malik Robinson. He's waiving.
Yes, Your Honor. There was an offer made here for that waiver to waive up and plead as charged on this matter in circuit court, as well as at the next hearing on his other felony matter. It's an Arno, except this Thursday, he pleading to an attempt Arno as a global resolution on that one. And that file was 26F5-500FY.
That's set for PCC or is that set
Yes,
before?
for PCC.
So that's going to be a waiver?
Yes,
That
Judge.
that one's going to be a misdemeanor plea at PCC.
Got it. Okay, then I won't try to do that today. All right. I was just gonna try to get everything together for him. Oh, but we won't do that. That's, Ms. Burnwell, that's your understanding.
Yes, Judge.
Sir, you're waiving your right to a preliminary examination in this matter?
Yes, Your Honor.
All right, and you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
You will also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we waive a reading of the information and stand mute.
Defendant having waived formal reading, standing mute as to both counts, court will enter a not guilty plea. Pretrial will be set for
At 1:30 before Judge Cook.
March 10th, 2026, 1:30 before Judge Kunke.
I didn't hear the name of that, Judge. You said Kunke?
Kunke, yes.
Okay, thank you, Judge. There's one more matter.
In this case,
Yes,
is it bond?
my client had, yes,
He's out. You want-
I know, but there's a,
No.
he wants permission to travel.
To where?
So he
So,
works,
no, so if I don't like the place, then no. No. Where's he want to go?
Your Honor, this is the situation. He works for Amazon. We all depend on them, right? Well, they're going in teams, traveling in teams
We,
to different places out
I
of state,
depend on Amazon? Yeah, yeah, pretty much.
to
Go
different places out of state.
ahead.
So he doesn't know exactly where now, but for the next 7 months, that's what they have to do. I guess that's why we get those packages so early.
Mine are always late. Where, no, on the one that's set for PCC. What is that charge?
I'll have to look. Obstructing.
The PCC matters of resisting obstruction charge.
Okay, because I have, the issue is that I have a bond violation technically on this one that results, as I'm to understand, because he picked up the other case.
I believe that's correct. I never received a bond violation report, so that was my understanding was the reason for the violation.
When is he supposed to start the travel?
Your Honor, it's within a week that he's supposed to start.
Does he have, you have any documentation indicating that that's it, that you put your hands on today? Because
Emails.
here's the deal, if I don't deal with it today, right, then I've lost jurisdiction on this case. And I can't do it. You follow me? So that's gonna be my problem. Then you'll have to get that before Judge Chunky before you can do that.
They won't let me get it. No, they won't even take me the information because I got the tether on my leg. So they won't even give me the information, the rest of the information because I got the tether on my leg.
Maybe the other alternative might be, well, you're up before me on Thursday, right?
Yes,
Or
he's
the
there on the
other day.
15th.
So can you put your hands on it by Thursday?
Yeah.
Huh?
Yes, Your Honor.
Okay.
The thing is, they didn't want to give him information because of the tether, because they see this as an impossibility.
Who?
The
Amazon.
job, right?
Yeah.
Amazon.
What did they
That makes
say?
sense. Who the hell?
So basically, so basically with this tether on, they won't give me no information on where I'm going.
Where? So because you have the tether, they'll keep you employed, let you do whatever you're doing.
I've been seasonal, it's seasonal. I'm seasonal worker.
So hold it, are you currently employed with them?
Yeah, I'm currently employed with them, but I'm going through a third party. We're going out of town. They just sending us out of town. They pay for everything.
I guess I'm not clear on this. So he's kind of employed, or he's employed by Amazon, right? He's going to go do training out of state, right?
Correct.
But you don't have the information regarding that training?
No.
But you think you can by Thursday?
Yeah.
Okay, so here's, because I'm gonna need that to give travel information on his other case in the event, right? So make sure when you come back on Thursday that you have that information that you can give counsel, okay?
Okay.
And then on this case, I guess since they don't have it, the best thing that
I guess I could bring a motion, an emergency motion.
Well, I think, or I don't know if the people have an objection to it.
Your Honor, if I get proof of employment, I'd be more than happy to stip to allow travel for that purpose.
Yeah, so, but, and then you could step and then Judge Kunke could sign it, right? But I don't know when that would happen and if it doesn't happen in time for him to travel. So I know what I'll do. I'll do it this way. What is that other case number?
It's 26F5-5000.
5,000?
Yes.
So 26F5, 5,000.
Yes.
That's the one for Thursday.
Yes.
Yeah.
So I'm gonna do this. This kind of does it backwards, but I think we'll get us there as long as you can get the information to us on Thursday. Okay.
Okay, Your Honor.
So what I'll do is I'll continue as bond in this case. But in this case, I will indicate that the defendant may travel as permitted in case 26F5, 5,000 for work purposes. So I've ordered that while I have jurisdiction in this case. It should carry over then when I order it in the other case, you'll have the same travel. Make sense?
Now, my next question is, can we zoom in for that? Or we have to be here physically?
See what I just did for her client?
You know what, Judge? I'm in an hour.
You see what I just did for her client? And then I do that. I like you. She's wearing on my nerves. But
All right, Judge. I'm in Ann Arbor on Thursday with Judge Slade. So
you were gonna go see Judge Slade and not me?
So I realized that.
No.
But if there is like the time conflict, I don't know if it'll be in the afternoon because he is, no, it's still in the morning.
It's at 3 p.m. on Thursday.
Is this? Oh, because it's a bond.
Or no, he's just out of custody.
He's just out of custody.
Yeah.
On Thursday.
He's putting up on Thursday.
Okay, all right, so what else do you want?
I'll be zooming.
I am trying to. She has time to file the form. I do.
Oh, I have time up until tomorrow?
Today.
You got about an hour and 15 minutes.
Oh, my God.
Is
Okay.
he gonna want to appear via Zoom also?
It could be.
Yeah, could be.
I can talk to people better when they're on Zoom and I'm on Zoom. When they're in the courtroom, it's like, it's unyoked, is that?
I like people in person. All right. Well, the problem is, he's gonna have to be here because he's gonna have to get me the form to
Paperwork.
stop, right? So I need him here. You fill out the form if you need to appear via Zoom if you're downtown.
Okay.
That was way longer than I needed to take with that at all. All right. So
Judge.
you got that so that we can get your paperwork so I can take a look at all of that. Okay?
That's right.
All right.
Thank you.
All right, folks. Thank you.
I thought I gave the waiver form.
You did. We were trying to help you.
Thank you. I can do it right now.
All right, sir. You're good. Take care.
It's a weird and wacky day here at TCF Live. It's been bizarre in the courts, especially in Simpson's. And is it just me, or is that defense attorney a character that has been lifted straight out of a Tarantino movie? I don't know. She just strikes me that way. Let's seek normalcy if we can. Let's say good morning to Judge Stephanie Boyd.
In the hallway, I love the dress. Yeah, no. I mean, the way you're dressed. Yeah. All right. So we're here for restitution, if there's any restitution.
Informed there was $98 worth of damage should be told, and then told defense if we are in agreement for the amount.
All right, we'll go on the record. The court is calling 2025 CR 012851 State versus Jasmine Lim. Can I have parties announced for the record for the state?
Patrick Valentine for Ms. Lim.
And are you Ms. Lim? All right, we're here for a restitution off the record. Parties had said they were in agreement to a restitution amount. And what is that agreement?
Yes, Judge, the agreements and for the amount of $98 restitution
And who is that to be paid to?
to the city of San Antonio.
Probation,
Yes, Judge.
there's to be $98 restitution to the city of San Antonio on Lim.
Okay, thank you, Judge.
All right, is there anything else?
I think that-
All right, we will close the record. Is she listed as being in jail because of?
I don't think so.
The GPS, I have a GPS tracking device. I'll get it taken off tomorrow.
Oh, okay.
Yeah.
All right, and that tracking is not for this court, it's for another court?
I don't.
No,
I think this is due on the matter, right?
Yeah.
Yeah. So
All
they're just
right,
taking a while to
so-
get it off.
It was, we agreed last time, it was 30 days instead of 10 days in Bear County.
Yes,
Oh,
okay.
Yeah.
All right, so then probation, her time on GPS should be up, you say tomorrow?
Yes, ma'am, at 9 o'clock.
All right, and let me, look in the notes. So make sure that I have that to sign to have it removed tomorrow by 9. Okay, all right, is there anything else?
No, Judge, thank you.
Anything else you need from the court?
No, thank
All
you
right,
so
you're
much.
oh, you're welcome.
Thank you.
Thank you. Anyone else ready?
Yes, ma'am, I have an MTR for Noah, page 14.
Oh, I'm not gonna need that because he is not gonna be here. All right, Nellum,
Nellum?
I thought he was in another county.
No, I did two jobs.
Hello.
Good morning, Your Honor.
Good morning. So this is a case where, hasn't he been found incompetent?
It was just evidently they dismissed that incompetence according to, I've been talking to Mr. Nello.
Wait, what, so I'm trying to understand, what do we mean the incompetency was dismissed? Yes,
He was found incompetent in, I believe it's Lincoln County, and then he was found competent, and then they dismissed the case that was held against him.
Ah.
So we're here today, we're going to withdraw all chain amendment and go with probation's recommendation.
all right, thank you.
Yes, Your Honor.
And probation, what is your recommendation?
I believe it's listed on the court summary, Judge.
It's the recommended state ISF, Your Honor, and then after that, he's gonna continue living with the group home that he's at.
All right, so Mr. Nellum,
Yes, Your Honor.
okay, this is what I can tell you. Your case in this court began before this prosecutor was here. And it took a lot of work for the state and your previous defense attorney, and now this defense attorney in probation, to come up with a resonance that was good for you because you were super young. I understand when people have mental health issues, I really do. And when I say I understand in, can I put this? I understand from reading, right, about mental health and what needs to be done with that. And I understand that sometimes people will go off their medications because they're feeling great, and medications have a lot of side effects. But with you, what you have to realize, the offense that you're on probation for is a serious, serious offense with serious, serious consequences that could result in you going to prison for a long time, right? And I'm not saying that I won't keep an open mind if another motion to revoke were filed, but I'm trying to let you know how serious this is. And I know you're young. So you're going to have to do your best to follow through. I'm going to talk to probation, and hopefully the group home where you can be placed, they'll give you a case manager, because you really need a case manager that you can report to at a minimum weekly, so that they can keep tabs on you, because your case, it continues from, when I first took the bench, right? So this has been going on since 2019 with your being in this court. So you're going to have to do it. And if you don't do it, there are going to be consequences. I know nobody likes being at the jail, right? Sure. All right. So let's go off the record for a moment.
Alrighty, well, she's off the record. We'll come back once she unmutes, but in the meantime, let's stay in Texas, but we'll go to Rock Hill West.
Good morning, sir. You're DeJuan Banks.
Yes.
And this is cause number 25 DCCR 0990. Mr. Banks is charged with injury to a child, elderly, or disabled individual. And Mr. Lewis, you need to watch
It's a guardhouse video, Judge, of the complainant, and I need to watch it with my client. He's
So-
currently housed at
Okay.
LaSalle, so I'll get it scheduled over there so I can bring my laptop.
Judge, just so the court is aware.
but you don't have the Garth House, do you?
Oh, no,
I will make
I
it
will.
available to it.
Okay, I say if y'all need to, what we've been doing is
Bring 'em
we
over
can
here.
bring them over here,
Okay, that may
since
be
it's not
easier.
something that you actually usually get a copy of.
That may be easy.
So get with Ms. Holmes and Ms. Malfino, and they can schedule to have Mr. Banks brought over. And you guys can watch it sometime the next week or two in the jury room, so that Ms. Malfino can bring that video down.
Okay.
So we're going to reset your case. Sometime in the next week or two, you'll be brought over to go over some discovery that's not allowed to be turned over to your attorney, that video. He doesn't get a copy of it, but you guys can watch it. So we'll make that available for you to watch here in the courtroom or in the jury room, and then y'all can discuss what you want to do. Okay?
And Judge, just so that the court is aware, if I may, this is a pretty discovery intense case, just based on the nature of the offense. I'm also intending to enhance it with a prior from out of state. I do have that judgment. I'll provide it to Mr. Lewis. Just wanted to let you know, if you see it come up a couple of times, we have talked about it. It's just rather discovery intense.
Okay, and you're going to get that notice of enhancement done? Okay, perfect. All right, Mr. Banks, you can go back with the bailiff. Thank you.
Interesting that there's a video that the defense is not allowed to have a copy of there. I assume it is a video of the actual offense taking place, and that would definitely speak to its seriousness. All right, Judge Boyd is back. Let's go finish that case.
Do you think we should start with him being on GPS at that group home if they allow that? I know we had some issues with charging the GPS last time.
Judge, I would say after his release from state ISF, I do recommend the GPS monitor.
All right, so this is what I'm going to do, since both parties are in agreement to it. I'm going to sign the motion to withdraw, alternate amend conditions. That's going to be ISF cognitive. And upon release from ISF, you're going to be placed on GPS. I'm going to ask that the fees be waived, because I believe he's receiving SSI as well.
You're not for cognitive, but for substance abuse.
Yes. All right, for substance abuse then. And is there anything else you need to be successful?
No, ma'am. I just wanted to say that it really is gonna help me. Succeed in life. If I do go to this program, it's gonna help me in a better way to stay off a lot of stuff and continue my life forward.
All right. And whatever medications you receive for mental health, you need to let them know that you have a substance abuse issue as well. And usually when you let them know that you have been in programs for that, they will give you medication that's a non-narcotic. Do you have any family support? I remember the last time I asked you,
I
no.
do have dad support, but that's the only person that I have.
Okay. All right. Thank you. Thank you, counsel.
Thank you, Your Honor.
Thank you. All right. Oh, that's it. Thank you.
Thank you, Judge. May I be excused?
Yes, and
Thank you,
if you
Judge.
could let him know, he's going to be in custody until he's transferred to ISF.
Yes, ma'am.
Thank you.
Yeah.
Alrighty, well, she's between contestants. Let's head back to Judge West.
And spinning, it's stuck. There we go. Mr. Chillo, if you'll step in front of the clerk, she's going to take your fingerprint in a second while we get these printed out. Everything's moving very slow this morning, so it's just spinning, and theirs are spinning. Is yours spinning too? Everything's just, yeah. 8447 Okay. Something going on.
Bizarre day in court continues. While they sort through their issues, let's try Judge Boyd again.
All righty. So this is scheduled for trial.
Yes, Judge. We were originally set last week, and I tried to explain to Judge Angelini at this time, resetting me to today was not feasible because I have a setting tomorrow morning in Kendall that they have no docket for me to get a continuance on. And I have a city council meeting tomorrow afternoon, and city council doesn't provide resets and continuances. And so we are ready, but because of those conflicts, I can't proceed today.
Your Honor, states that we have no objection to.
All right, we're going to go on the record. The court is calling 2025 CR 008809 State versus Loretta Ramos. Could I have parties announced for the record?
State.
Elizabeth Russell for Ms. Ramos.
And are you Miss Ramos? Yeah. And it's the court's understanding from reading the judge's notes that this case was set for jury trial on January 6th. Defense counsel filed a motion for continuance. Judge Angelini granted the motion and is reset for jury trial today. And counsel, are you asking to orally amend that motion for continuance and have the court hear it?
I am, Judge, and I have another one that I have verified that I need to file as well if the court needs me to, that is going to explain everything that I'm about to tell the court.
All right, any objection to the oral amendment to the previous motion for continuance?
No, Your Honor.
All right, and what is the reason for the request for the continuance?
Your Honor, I have conflicted settings that I was not able to secure even a court appearance to ask for a continuance in. Those conflicted settings, unfortunately, are in municipal court this morning at 10 o'clock, this afternoon at 1:30. They provide no opportunity for us to even get resets. The only way we can get a reset is to appear. And when the reset is necessary because of a conflict, that obviously provides no opportunity for counsel to get that reset. I had made these settings because I didn't have any criminal settings on this day.
In municipal court, you guys are trying to murder something, right?
It's actually more difficult to try a municipal court case than a murder, unfortunately, Judge. And then I also have a municipal court setting tomorrow morning. I have a Comal court setting tomorrow. I'm sorry, a Kendall County setting tomorrow morning. And then in the afternoon, I have a city council meeting. The city council meeting is actually the one that's of the utmost priority. We have had to reschedule several times because of things that the city council was requesting that we do. It's for a modification to a plan, like a zoning plan amendment. And there is no mechanism for providing a continuance other than showing up for those
Oh,
meetings.
no, I've done work when I was a defense attorney with zoning, so I realize it's hard to get a reset, and once, it's hard to get a hearing there, and then to ask for a reset is very difficult. State, do you have any objections to the continuance?
No, Your Honor.
All right, so the court will grant the motion for continuance. This jury trial, how long do y'all expect it to last?
No longer than
2 days. Yeah.
All right. So confer with Ms. Ferguson, get a jury trial date, and that will be your jury trial date. Just have a seat. Your attorney will bring the reset form to you.
Give me just a second. And Judge, do you want me to file that other verified motion for continuance as well? I'm happy to.
They've already said they had no objection to the oral.
Thank you, Judge.
You're welcome.
That's right. Like too much.
Ever find the Herrera file?
You wouldn't have to file for that one right now. Because it's docket and it's not.
Okay.
All right, Norma, do you have a date for them for?
No, I don't. You said 2 days.
2 days, yes. I do have another matter that I need to approach on that you don't have a file for,
Oh,
Judge.
just give me a moment. Let me do this first, and then we'll move on to the next matter.
Yes, Judge.
Judge, I can do March 17th.
I start maternity leave March 1st. I'm due the 12th. I'd like to do this before then, if the court's available.
I'll have to,
February, my client has I'm sorry, my client has a surgery the last week of January. She needs 1 week of recovery.
Okay.
February 23rd works great.
All right, we'll put it for that date. However, there may be other matters that are before you.
We understand, Judge.
All right. So that's February 23rd, Norma?
Yes, ma'am.
State, that's been reset for jury trial February 23rd. All right, who's next?
Yes, ma'am. It will be the same attorney. It's going to be for. What's his name?
Rosendo Herrera.
Rosendo Herrera, page 11, the second one down.
Rosendo Herrera. Come forward. All right, so my understanding from the judge's notes that he was a plea to the misdemeanor case, applied a misdemeanor BTC, and then if accepted, this case was to be dismissed. Where are we on that?
I made, upon conferring with the felony ADA, I made representation to the VTC court that this case is being TIC'd. Apparently, they need that representation to be made from the state, and they refused to screen him until that happened. After repeated email chains, they finally accepted the representation by the state, and so he's set for screening January the 20. When did they contacted you? Email chain? Yeah, okay, give me 1 second.
All right, let's do this.
For January the 22nd, but the expected plea date is not until March, Your Honor. And I have someone on standby to cover that plea date because the VTC program apparently has a long wait list right now, and we don't want him to miss an opportunity.
All right, so what date in March?
Okay, everybody, okay.
Let's do this. Norma, let's recall this for April 2nd. And then, however, if everything is completed before then, the state will bring a dismissal to the court and you will not have to appear. All right. So here's my other question. Why were you late today?
Was a 9 now.
Okay, so here's the thing, in this court, I require that everyone be here at 9, so make calculations so you can be here on time, okay? All right, just have a seat. Once you sign the reset form, you're excused.
Thank you.
You're welcome.
Then take a seat and grab a flower pen. Thank you.
Okie dokie, friends. Let's keep bouncing back and forth in Texas. Back to Judge West. Seems to have things rolling now.
Hello, in cause number 19-32403, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 5th of 2021 for the second-degree felony offense of sexual assault of a child, and that was a 10-year deferred probation. Is that correct? Yes. And then in cause number 19-32404, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 5th of 2021, also for sexual assault of a child, a second-degree felony. That was also a 10-year deferred probation. Is that also correct? Yes. Each of these cases, excuse me, allege that you violated your probation. Count 1 alleges in each case that you failed to successfully complete the sex offender counseling and that you were terminated from the program July 25th of 2025. And is that true or not true? True. Count 2 in each case alleges that you possessed sexually stimulating or oriented material on your phone in violation of your probation. Is that true or not true? True. Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? Yes. And because you actually did those things in counts 1 and 2? Yes. All right, then I'm going to find in each of the cases that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. However, I'm going to reset your case for sentencing, ask the probation department to do an updated report for me. Anything that you think is important, give that information to Mr. Lewis. He will present it to me on your behalf when we come back. And just for the record, is my understanding this is unagreed, just going to me for punishment, correct?
Yes, ma'am, correct.
All right, we'll see you back at sentencing. You can go back with the bailiff. Robert Eaglin.
Robert Eaglin.
Already has a trial date set for next week.
And this was just for competency. And you're on it for the trial already. We've done all that. All right. Good morning, sir. You're Robert Eaglin. And this is 24 DCCR 2382. I'm going to take judicial notice of the court's file. Mr. Eaglin was evaluated for competency to stand trial by Dr. Krapon. I've received that report dated December 3rd, 2025. The finding in that report is that Mr. Eaglin is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Then based on that report, I am at this time going to find that Mr. Eaglin is competent to stand trial. And then Mr. Lewis, you mentioned this is already set for trial, correct?
Set for trial.
And is that what you intend to do, is go forward with trial?
Yes, ma'am.
Set February 23rd, trial.
Okay, thank you. Then I will set that case back on that trial docket and we'll get it taken care of hopefully as soon as possible. You can go back with the bailiff. Thank you.
Sure.
Mr. Parker on Herbert DeBlanc. Good morning, Mr. Coleman. Are we
Yeah, I
going,
don't think he'd take anything. He wasn't doing.
good morning, sir. You're Herbert DeBlanc,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. DeBlanc, in cause number 22-40044, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. That's from February 19th of 2021. Count 2 alleges that you were previously convicted of failure to comply with sex offender registration requirements, a second-degree felony, September 10th of 2015. And how do you plead to that charge? And is that prior offense true, conviction? And are you entering your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. DeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Thank you. You too, sir.
He just actually. Like the very nice guy.
Yeah.
And he was registered, he was just in jail and out of jail.
Jesse Griffin, Mr. Parker.
Good morning.
Good morning. Good morning, sir. Are you Jesse Griffin? Yes, ma'am. And Mr. Griffin, in cause number 25 DCCR 1397, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 28th of 2025. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a document, plea bargain rejection, that has your signature on it with Mr. Parker's, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Griffin, Mr. Parker has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Griffin, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Brandon Murphy, Mr. Parker.
Brandon or something.
Oh, Brandon. Of course it is. Brian.
Thank you, Barbara, for the gift of membership. I appreciate that.
Are we going to go and count one only?
Yes, yes.
What would be, what are the sentences in all of those 2022 cases? There's 1, 2, 4 from that same date.
We got 2 years, 6 years, he said.
So still on parole.
Yes, he's still on parole. He's a parole.
I guess I'm just looking at the agreement and having some
There were some
concerns.
There were some issues just for the court that of how they charged it. Normally it would have been unlawful use, UMV, but there's some evidence that the girlfriend may have been the one that took the car. She was the one that was driving the car whenever he was actually stopped, when they were stopped. So there's
This hurts.
Okay. All right, that's what I need to know. And will he waive the formal reading of the indictment?
He will, Your Honor.
And sir, is it Brandon Murphy?
Yes.
And Mr. Murphy, in cause number 25, DCCR 1678, the state's elected to proceed on count 1 only. It alleges you committed the state jail felony offense of theft of property from August 16th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Speak up.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murphy's not competent?
Thank you, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Jaden Simon.
Barbara, thank you for gifting a second membership. I know you're trying to target somebody. Doesn't look like you were successful, though, but thanks for trying.
Good morning. You're Jaden Simon. Give me just a second.
And Your Honor, just for the court, there's two different cases, and the state filed a motion to stack, and I didn't reflect that on the deal because it wasn't part of the plea offer, but I've explained to him that that's the intention of the state if they go forward.
That's correct.
Okay, so the offer is
20
for
CC.
to run concurrent. Okay. All right, and so Mr. Simon, in cause number 25 DCCR 1760, you're charged with the first-degree felony offense of aggravated robbery from October 10th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And in cause number, hold on a second, it's not right here in order. (25) DCCR 0918. Sorry, y'all. You're charged with the second-degree felony offense of robbery, and that's from June 12th of 2025. In that case, what that means is if you go to trial, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 20-year term in each case, and that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. I do want to make sure you understand what your options are and what the possible consequences are if you go to trial. So in addition to also those two, because your offense dates are on 2 different dates, what that means, and the state has filed a motion, is that if you are found guilty in both of those cases, then they could ask me to run those sentences consecutively or stacked on top of each other. I want to make sure you understand that, and that what the offer is for those to run at the same time. Do you understand all of that?
Yes, ma'am.
And Mr. Coleman, is there any reason to believe that the offers in these cases would change after today?
Not at all, Judge.
No evidence you're waiting on or anything like that?
No, Judge.
So, Mr. Simon, I also want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different or open to the court. Do you understand?
Yes, ma'am.
And do you want to reject the offers and have both cases set for trial?
Yes, ma'am.
All right, we'll get those set for trial. And Mr. Simon, Mr. Parker has been appointed to represent you on your cases, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I could release him and appoint a new attorney today that could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Simon, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
You can go back with the bailiff. Kelsey Wilson.
Michael, thank you for gifting a membership. You can actually see Michael tonight on this channel along with myself and Ashley and Austin on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, so check that out. Barbara, thank you for gifting another membership. And Grandma TCF, thank you as well.
Mr. Lewis, you have William Jones. It's like 4 cases.
William Jones.
And there's not paperwork on these.
No, ma'am.
Come on here, pull in.
So all four of them, right? And the four off, right? Same place.
Where you going?
Good morning, sir. Are you William Jones? And in cause number 25 DCCR 1627, 1628, 1629, and 1630, Mr. Jones is charged with theft of property with previous convictions. And what is the announcement?
Judge, on this, when I talked to Mr. Jones about this situation, I do need to do a little bit more digging into his priors as well as go over some discovery with him.
Okay.
So I'll do have one more reset.
Sure. Any issue?
Okay.
All right, we'll just do a normal reset. Mr. Jones, Mr. Lewis will be out to see you to go over everything, and we'll get an announcement at the next court date. You can go back with the bailiff. And Crystal Julian. And this one, we're just going on one of them.
One of them. Yes, ma'am.
And
are there priors we're going on?
yes, two state jail priors, judge that enhanced this to a third.
Okay,
And they're
perfect.
both over 10 years old.
Thank you. Good morning, ma'am. Are you Crystal Angel Julian?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Good.
Ms. Julian, in cause number 25, DCCR 1393, you're charged with the state jail felony offense of burglary of a building, and that is from June 26th of 2025. Your indictment alleges you were previously convicted of burglary of a building in two cases, state jail felonies, on August 27th of 2012, and after those were final, you were convicted of possession of a controlled substance, a state jail felony, July 10th of 2015. And how do you plead to those charges, or that charge?
Guilty, ma'am.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a dismissal in cause number 25, DCCR 1394. You would also be ordered to pay restitution as determined between now and sentencing, and for both of the cases, even
Yes,
the
ma'am.
one that's dismissed. You understand?
Yes, ma'am. Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Julian is not competent?
No, Judge.
Ma'am, I'm going to find that you entered your plea of guilty and true to those priors freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your cases, and then we will come back later for sentencing. I'm not inclined to do anything with the bond. I want to make sure what was going on based on that history, if there's any other substance abuse or cognitive issues that need to be addressed at sentencing. All right, you can go back with the bailiff.
Thank you, Judge.
Thank you. Ms. Holmes, you've got Otis Wilson. Good morning. Any No paperwork on this one?
Yes, we did paperwork.
Do you have Otis Wilson's paperwork?
Yes, ma'am, I'm sorry, I've had some issues. Judge, it says you it's corporate rules, so you should be very hot.
Oh, there it is. Sorry, that was, all right. You are Otis Crawford Wilson?
Yes.
And will your client waive the formal reading of the motion?
Yes, Your Honor.
Excuse me, Mr. Crawford Wilson, in cause number 20-34521, I have a motion to revoke your community supervision. It shows that you were placed on probation October 21st of 2020 for the third-degree felony offense of escape while arrested or confined, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community services directed. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 alleges that you failed to pay your court-assessed fees as directed. As of September 22nd, 2025, you were $3,550 behind. And is that true or not true? And then count 3 alleges that you failed to enter and successfully complete the JCDI program as required. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Crawford Wilson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
So as you guys know, I monitor a whole bunch of different courtrooms, including the Louisiana Pardon Board. And there's a hearing going on there right now that I can't go to at the moment because we don't have time for it. It's been going for a good 45 minutes now. But there was a victim statement there where the guy was getting very, very animated, at least with his facial expressions. And then I turned on the volume and he was, yeah, I mean, not like out of line crazy, but definitely impassioned. So I think we might start our day tomorrow there while we wait for the courts to come online. We may go in the Wayback Machine to start tomorrow. But let's change it up here in real time. Let's go back to Judge Boyd.
According to the notes from Judge Angelini, there was some sort of an agreement, or is that no longer the case?
I thought we had one, but then we didn't.
All right. Who is the prosecutor on Andrew Barham?
Morning, Bush.
Good morning. So the defense said that there's no longer an agreement.
No, Judge, there's not an agreement.
All right. So, Norma, then do you need more time? Because normally in this court, I give plea deadline dates. Do you need more time? Otherwise, you're going to get a jury trial date today.
What do you think? I think we're ready to proceed, Judge.
All right, Ms. How long do y'all expect this trial?
Shouldn't be too long, Judge, maybe an afternoon.
Ah, so Norma, 2 days.
2 or 3 witnesses, yeah.
Yes.
The 20th.
Judge, I can, I'm in trial in Bastrop County.
Oh, which county?
Bastrop.
And where's Bastrop? I'm learning my counties.
Oh, sorry.
So that's why I asked.
So Austin, Bastrop is about 30 miles east of Austin.
Okay, that helps me.
Yeah.
Yeah.
It's on-
All right, so how long do you expect that trial to last?
We picked the jury on Friday of this week. Monday's a holiday. So Tuesday and Wednesday at least. And then it's my wife's 40th birthday at the end of the week. So I was taking her on.
Well, you got to celebrate that. Otherwise, it
She
may
may
not
not
go
be
well.
around next year.
Or does she want to go by herself? All right, so what date?
I heard you say that 2/23 date. I don't know if that's too far out.
Well, the only problem is there may be other people set, and with him, because of the evaluation that was done and it being restored, I'd rather do it sooner than later.
Understood.
So when do y'all get back from your wife's celebration
Thank you. We return on the 26th.
of January?
Yes.
Norma, do we have a date? The beginning of February, maybe?
February 3rd.
All right, you'll be scheduled for jury trial February 3rd. Counsel, with regards to the clothing exchange at the jail, Deputy Laura, how many hours?
72.
You have to do that exchange 72 hours beforehand, not 71, not 73, exactly 72 hours. If you don't, there's going to be an issue with the clothing exchange. They put that in effect probably like months ago. It may have changed, so you may want to double check. You need to sign a clothing exchange. If you don't sign it, you're going to be brought over in whatever civilian clothing you were arrested in.
I understand, Your Honor.
All right, and Norma, you said February 3rd?
Yes, ma'am.
So your jury trial date is going to be February 3rd. I'm going to make that a jury trial date and a plea deadline date. Is there anything else?
No, Your Honor.
All right, I'll need an acknowledgement of discovery for you all to do that and sign that before you leave.
No problem.
All right, thank you.
Thank you, Judge.
You're welcome.
Your Honor.
You're welcome.
Nina?
That
Sabansky? Probation, this is a plea. Good morning. I understand you're in jury trial.
I am.
All right, so we're gonna.
Second one this year.
Oh, it's hard to believe it's 2026, right?
Hey, but I'm 1-0 already, so I'm off to a hot start.
Oh, hey. So how were the holidays for you guys?
Excellent.
Oh, that's good.
Couple days
Me.
off, never hurt anybody.
Oh, yeah. Yes. And Mr. Blank, it was excellent for me too, as you
Hey,
know.
I saw that. That was
Yeah.
fantastic. Although the candle is still lit.
Yes.
Not time to ring the bell quite yet.
Mm-hmm. All right, the court is calling 2025 CR 006420 State versus Corbin Samansky. Can I have parties announced?
Charles Bunk and Clint Glendy for the defendant.
And are you Mr. Samansky? State, have you received all discovery? Did you review? I'm
Defense.
sorry, defense, did you? You can tell I'm just getting back, right? Defense, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Samansky, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorneys? Did you understand it?
Yes.
Counsel, do you waive the reading?
We do.
State proceeding on the indictment as presented?
Yes, sir.
Mr. Samansky, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Szymanski, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 7 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There's no application for community supervision. The state is opposed to your application for deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be the plea? Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states one in attachment.
No objection.
Right. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court will review the same.
Second row. Over here.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So Ms. Ferguson has given me a date of April 13th.
Yes, Judge.
For a PSI.
Yes.
What will end up happening is they will interview you, make sure that you make all your dates. There'll be different dates set for each interview. Is there a need for a TAP evaluation?
Yes.
Any mental health evaluation?
Judge, he has.
Yeah,
Any MIC
yes,
evaluation?
yes.
All right, Vashon? Okay, it's gonna be a PSI and TAP evaluation and a MIC evaluation on Szymanski, and we'll be back on April 13th for sentencing. All right, once you sign the reset form, you are excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Alrighty, Texas is definitely where it's at here in the third hour. Let's go back to Judge West.
Did you see the response?
I would have served it on you back on.
Yeah.
I have it in my email.
It's been a little bit.
It's been a while, yeah, because I filed the motion a while ago.
December 17th is
Okay.
my certificate of service.
All right, so are you Jonah Johnson?
Yes, ma'am.
And Mr. Johnson is charged in cause number 25 DCCR 1775 with aggravated assault with a deadly weapon. And Ms. Holmes has filed a motion asking that Mr. Johnson's bond be reduced. It's currently set at $300,000. And then there's also 2 misdemeanors that he has as well. And those bonds, it looks like, are $3,000 and $5,000, which we're not discussing, but just that he has the charges also, in addition to aggravated assault with a deadly weapon, to misdemeanor charge of unlawful carrying a weapon, 2 cases of unlawful carrying a weapon. And so Mr. Coleman filed a response, obviously in opposition to that. Ms. Holmes, Mr. Johnson, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. You may proceed, Ms. Holmes.
Thank you. Mr. Johnson, how long have you been incarcerated at Jefferson County Jail?
2 months.
Okay, and in that 2-month span, your bond has been set at $300,000, is that correct?
Yes, ma'am.
And has your family tried their best to secure or try to get you bonded out at that amount, have been unsuccessful?
Yes, ma'am.
Okay, now, prior to this, was your bond originally at a different amount and was it raised at some point?
Yes, ma'am.
Okay, and do you have any property or anything that you could possibly sell to secure where the current bond amount is?
No.
Okay, does your family have any type of assets or property that could secure at this amount?
No.
Okay, are you requesting that the judge lower the bond to give you an opportunity to bond out, and whatever stipulations the court may have, whether it's a GPS tracker or home confinement, would you be willing to abide by those restrictions?
Yes, ma'am.
And where would you be residing if you were able to bond out?
I'm on the side.
Okay, and where is that, in Beaumont?
Yes, ma'am.
Okay, and your mom is here today, correct?
Yes, ma'am.
Okay, and she would be able to let the judge know that that's where you would be residing?
Yes, ma'am.
Okay, and since you've been incarcerated at the Jefferson County Jail, have you received any write-ups?
No.
Okay. At this time, I'll pass the witness, Your Honor.
I have no questions for the defendant, Judge. Just argument, please.
Okay, so just for the record, I'm taking judicial notice of the court's file. It does include an affidavit of surety surrender. That's where the bond got increased, because the bond's been filed, that affidavit, because it reads that the defendant failed to pay for his GPS device. It had not been charged at that point, so this, it says since 11/7 of 25, and this was filed November 19th, so it hadn't been charged for a couple of weeks, it looks like. They further stated that he will not respond to their attempt to reach him, and he cannot be located. Therefore, they felt like their bond was at risk, and that's why they filed that affidavit to get off the bond, which was granted, and that's why that was raised. Give me just a second. I also want to take a look at the probable cause affidavit, just so that I can have an idea of what we're talking about. Mr. Holmes?
That probable cause affidavit, I'd like to offer, for the limited purposes of this hearing, the surveillance video from the apartment complex of the incident.
Okay, thank you. Any objection for this hearing?
No objection.
I'll take a look at it. Give me just a second when I take a look at this. Mr. Coleman, I'm ready.
Before I show the video, I just want to highlight in my reply, the defendant Scott, he has 9 prior arrests, 2 of which were for unlawfully carrying a weapon. Those cases were pending when he committed the instant offense. Judge, the video, I'll just summarize by saying it's like a Wild West shootout in broad daylight in the apartment complex. Here's the video there. You can just hit play there. Of course.
And what about Kendrick O'Feel? Is he charged as well?
I don't think he got charged.
He was the other shooter,
Yeah,
according to
he would
the
be the person in the video
PC.
there in the front. They're saying at the front of that red truck. My understanding is that it's the defendant here who's in the background wearing the dark colored clothing.
Okay.
And the bystander who is shot, you'll see her behind like that white van.
Okay.
Because I think the young lady got charged with tampering. I think the one that got shot got charged with tampering. Kendrick.
In that video, it also appears that the first shot, and it's obviously not the best angle, but anyway. The motion's denied. You can go back with the bailiff. It's crazy. Insane. Nope, you need to go back with the bailiff.
Well, alrighty then. She shut that down in a big ol' hurry. Let's go to Judge Boyd before we go to overtime.
Do you have a copy of the latest supplemental report sent in?
Let me see.
If not, I can make a copy real fast.
Oh, all right. Thank you.
Okay, Judge. So there was a supplemental report sent into the court in November. There were some concerns in regards to some positive UAs, a admitted use in some failed racks on his device. All of these occurrences happened in July of 2025. The court was not notified of these until November of 2025. In July of 2025, a TAP was completed. And at the time, the recommendation was for him to do SATIV. He has completed his DWI education, his victim impact panel, and provided his DNA sample. After July, he has not had any positive UAs. That's August, September, October, November, and December. And he has not presented any high BRACs on his device. He does tell me that he is attending AA 2 times a week. And I would ask that the court consider if we can do intensive outpatient treatment and continue his AA meetings. I believe with speaking with him, he understands that he cannot drink. And at that time, I think some things were just happening in his life and he did not know how to possibly handle them. But speaking with him, he's on the right track at this time. So we're asking that intensive outpatient be mandated.
All right. So here's the thing. I was informed late that you had this violation. And one of the notes that's on this supplemental report for me is that inpatient treatment would have a significant impact on your family. And I'm sure the impact would be financial because you're an inpatient, you can't provide for your family. These are things that you need to think about when you're thinking about drinking. Because when you're on probation, you're not allowed to drink alcohol, and especially with the offense that you're charged with. I always tell people you need to stay clean and sober for yourself, but if you don't want to do it for yourself, you have to do it for your family. And if you're around people who are drinking or who are encouraging you to do, because I know sometimes that happens when people will tell you, oh, just one more drink, one more this, you need to start thinking about your family if you're not thinking about yourself and your sobriety. Do you understand?
I have declined several invitations, to family gatherings and stuff like that. Honestly, on Christmas Day, I was by myself. New Year's Eve, I was with my in-laws, so I was, around, good folk and around surrounded by all that, substance and, like I told her, I've been doing AA meetings, twice, 3 times a week, from 8 to 9, and sometimes just spending time with my family because I don't know what's gonna happen. And I just got a brand new home December 12th, closed on it, and that got that from the family. So I feel like I'm on the right track, doing this thing of life, well now. I'm understanding everything now, just thinking like how I should be, like a 28-year-old man, who just wants to provide for his family. And the little one, we take her to speech therapies twice a week, Tuesdays at 4, Wednesdays 4:30. So it's just kind of tough, just to let that let my wife handle all that just because of my bad decisions and my choices.
Okay. All right. So this is, well, probation, you're asking for intensive outpatient. Do you think, based upon what he's saying and the fact that he's doing sober support meetings, do you think we should just start with outpatient treatment and then if more is needed, do intensive, or you think we should start with intensive?
We can start with supportive, Judge.
Okay. So here's the thing. If supportive outpatient treatment is not working for you, you need to let probation know. Nobody's going to revoke you because you say you need more treatment. Probation is designed for you to realize what your triggers are so you won't come back to court anymore. Okay? Is there anything else you need from the court?
I said, no.
All right. So what I'm going to do is I'll order supportive outpatient treatment and you to do sober support meetings at least once per week. And if you ever think you're going to drink, pick up the phone, call probation. You know what they're going to do? They're going to make sure that you get in touch with somebody who can help you, maybe not take that drink. When you're doing your sober support meetings, talk to people and see who will be a good sponsor for you. Yeah. Sometimes it takes people years to figure out the sponsor that they mesh with very well. So you need to do that. So you'll have a support system where people you can call.
Yes.
All right.
Yes.
Is there anything else?
No, Judge.
All right. Thank you. Thank you for dressing appropriately for court.
Okie dokie, friends, it is now TCF overtime. It will be abbreviated today. Apologies, I cannot do a full hour of overtime. Mrs. TCF has a medical appointment that we're going to have to get to, so we'll cut it a little bit short. But there are a few things that I made notes on and want to cover, and then something else that just popped up in my news feed. And maybe we'll start with that. Let's go here. Well, we'll start with that if it works.
More federal agents to combat the rioters
There we
in
go.
that state. Matt Finn joins us live in Minneapolis with the details.
Forgive
Hey,
me.
Matt.
Still figuring out the workflow for all of this. It's a little bit different.
DHS sources
Okay,
tell
so
Fox up to
U.S.
1,000
Marshals are
additional
seeking
agents
actor
will
Timothy
surge the
Busfield
Minneapolis
after
area.
child
That's on top of
sex
the already
abuse
2,000 agents
allegations.
that are here.
How
But the Democratic
weird
Mayor
Hollywood
Jacob
not
Fry
behaving
says
properly.
these agents are going
Best
to
known
be
for
met
roles in 30-something in the
resistance.
West Wing. Days after authorities in New Mexico issued an arrest warrant for 30-something alum Timothy Busfield on child sex abuse charges, the U.S. Marshals have stepped in, taking over efforts to locate and apprehend the actor. Mrs. TCF was actually telling me about this, that she saw in her feed a day or two ago that there were charges being filed against him, but it looks like it's elevated now. Albuquerque PD is working with the Marshal Service to get Mr. Busfield into custody. On January 9th, an arrest warrant was issued for the director and Emmy Award-winning actor. Investigation by the Albuquerque PD filed a complaint in support of the charge, which says the child reported that Busfield touched him inappropriately. The alleged acts, which happened when the child was 7, occurred on the set of The Cleaning Lady, a TV series Busfield directed and acted in. Allegedly touched the child 3 to 4 times and again another 5 to 6 times when he was 8. Health and safety of our cast and crew is always our top priority, especially the safety of minors in our production. A representative for Warner Brothers told Fox Digital in a statement. Warner Brothers is in the process of trying to be bought, so that'll be interesting. We take all allegations of misconduct very seriously and have systems in place to promptly and thoroughly investigate, and when needed take appropriate action. We're aware of the current charge and have been and will continue to be cooperative with law enforcement. Police investigation began on November 1 of 24. So that's been... The investigation's been going on for a long time. And I wasn't aware of this. Married to Little House on the Prairie actress Melissa Gilbert, who deleted her Instagram account after the arrest warrant was issued. So, sad, somehow not surprising, Hollywood behaving badly. Anyways, that just popped up in my feed and is definitely law and court related, so I will keep an eye on that and see how quickly in and out of the federal facility. Now, Fox News did apprehend him. It's interesting that his wife deleted her Instagram account around the city, even after the shooting. It's hard to hear you. There's audio in the background. Even intentionally blocking in federal agents. At one point, Border Patrol warned 2 women to stop trailing them. Oh, was there audio? Oh, is there audio now, or was it from that? Interfering with us. Honking your horn, blocking our cars. It was in that tab. There shouldn't have been. I had that tab muted. How weird. Bad decision and being arrested there. Well, apologies. You know what? It's still there? How? This is a day, my friends. It's a bad day. All right, is it better now? Oi. You know what? This is live right here. This is real life, and you know, we often get criticisms of, you know, and all YouTubers do better, try harder. Why don't you do this? Why aren't you more professional at that? This is real life, and sometimes things work and sometimes they don't. We started our day with Ellie pushing buttons and pulling plugs during the pre-show, and it's just kind of gone on from there. So apologies for that. Anyways, if you didn't hear it, Timothy Busfield, actor, U.S. Marshals seeking him. And yeah, Wahoo says, get with it, Dan. I'm trying. I'm trying real hard. But this has been a weird day, you've got to admit. I mean, courts had tech issues. We had issues here. Simpson went from being super happy to probably wanting to hurt people. It's been odd. What are you going to do? This is what makes life fun. I would agree with you. Okie dokie, what else do we have? Oh, I wanted to comment on the whole Judge West thing, since we just did crimes against children with Hollywood there. So she had the one person who was being revoked on a crimes against children thing. 2 issues with that. First off, why is somebody who commits a crime against a child being put on a 10-year probation? If it's serious enough to put it on probation for 10 years, It ought to be serious enough for a state jail or prison sentence. Barbara, thank you for the $5. I love you too. So thank you so much. But wouldn't you agree? Shouldn't it ought to be serious enough at that point for there to just be some kind of state jail or prison sentence if you're going that far? So that's my first problem with it. The other problem I had with what we saw in West's court there is they never make it 10 years. We've been through this so many times. The odds are incredibly slim. They get a little bit better the older you are, but still it's under 50% that make it the full 10 years. I think it tops out at like 38% if I recall the stats correctly. I didn't have time to pull them up again. And it's as low as like 10 or 11% if you're under 25 when you're sentenced to that 10-year deferred or 10-year probation, either way. 10 years of trying to behave yourself, it just never works. So I'm so frustrated about when they do that. Charles says, I need to know more about the fact pattern. Yeah, but I get what you're saying, but I don't like the 10-year thing. I never have. If it's, again, I know I'm speaking in circles here, I suppose, but if it's so serious that you've got to watch them for 10 years, I think there has to be some jail time involved. I just do. Because it just not in absolutes. You can't deal in absolutes. It's not that it never works. It's that it very seldom works. And we see these people, they rotate back and they end up getting sentenced anyways. So there you go. I don't know. That one, when I saw it, bothered me. So there's that and that. Barbara, I looked up judges' age requirements and pulled some data for several states. Let me get that pulled up here so I can read it, because it varies. You'd asked if there was a certain age that they needed to be. So I pulled up more data, and I've got it for a few different states. California, for example, if you want to be a judge, they don't have a minimum age there. But you have to be admitted to the California bar. You have to have been practicing for at least 10 years. They, interestingly enough, though, do not specify a residency or citizenship requirement. That seems dicey to me. Texas, minimum age is 25. But interestingly enough, you have to have been practicing for 8 years. So if you do the math on that, you would have had to have graduated law school and immediately started practicing by age 17. I suppose if there's a Doogie Howser Law edition out there, that would work. But you have to have been a U.S. plus Texas citizen and a resident in the district for at least 4 years. They do have an age max there of 74. Florida does not specify a minimum age. You have to be a member of the bar. You have to have been practicing in front of trial judges for at least 5 years. You must live within the geographic area that you served. Arizona, you have to be at least 30. You have to be part of the AZ bar. You have to have been practicing for 5 years. You have to have been an Arizona resident for at least 5 years. Michigan, we go there a lot. No minimum age specified. You have to be admitted to practice law in the state. You have to have been practicing for at least 5 years. They do not specify a residency requirement. And as we know from Judge Middleton, who is done at the end of this year, you cannot have an election or appointment after the age of 70. So after that, you finish your current term and then you age out. State of Washington does not specify an age. You do have to be admitted to practice law there. They do not specify an amount of experience. You do have to be under 75, though. Georgia, you have to be 30 years of age. You have to be in the bar and in good standing. You have to have been practicing for 7 years, and you have to be a citizen of Georgia for at least 3. Illinois merely says you have to be a licensed attorney and a U.S. citizen and a resident of the area in which you'll be sitting on the bench. Colorado, no age requirement. must be licensed to practice law, must be 5 years in law, and you have to be a resident of the district and under 72. North Carolina says you have to be at least 21, you have to be licensed to practice law, and you have to be a qualified voter, which is an interesting distinction there. So those are just a sample of different things from around the United States that are the requirements depending on what it is you're going to do. Yeah, Washington, the example I read there, Charles, was specifically for the Superior Court. That's the data I was able to capture. But it varies, is the bottom line. And then if you're just going to be a magistrate, there's completely different rules there as to what you need and what you're allowed to do. So, Barbara, I hope that gives you a little more information on that because you brought that up earlier. So that's out, that's out. One more thing before I cut you guys loose. And again, apologies that it's a little abbreviated today. So yesterday we were talking about my thought experiment and my thesis on how we had the milk carton kids in the 80s and the stranger danger and all of that, and how that helped move kids indoors at the same time that video gaming and the internet was starting to take hold. So now we've got all these kids indoors, they're on the internet, and it opens them up to this pathway for predators, right? So I continued with that thought experiment a little more and gathered up some data. And I asked myself this question, and I want you guys to think about it. And you can let me know what you think when we're done here. Would you rather have your kid walk home alone, or would you rather let them have private messaging? So DMs. So access to DMs or the ability to walk home alone. So let's go through the data. And we'll start playing with side A of that, and that's letting them walk home alone. And I would argue that there's a real risk in letting your child walk home alone, but it's not in the stranger abduction area. It's in traffic. In 2023, 171 child pedestrians, so age 14 and under, were killed, and just over 7,000 were injured in pedestrian traffic crashes. So there's some danger there. If your child's under 14 and they're walking around, you know, when you consider the amount of children in the United States, is it a huge risk? No, but it is present. It can happen. And those deaths tend to cluster right around when kids are out and about. The highest share of those deaths occur between 3 and 6 p.m. and between 6 and 9 p.m., which are kind of the classic after school and after school activity hours. So when school is over and when the extracurriculars like sports and stuff are over, that's when these things tend to happen. So there is a real risk there. But what about the abduction end of things? So that's the traffic where there is real danger. But non-family abductions are the rarest category according to NCMEC, the National Center for Missing and Exploited Children. It only makes up about 1%. So 99% of the cases, the abductor of the child is somebody who is known to the child, usually a family member, sometimes a friend. The worst case abducted and murdered scenario, when it happens, it moves quickly. This is FBI data. They say that 74% of abducted and murdered children were killed within 3 hours and 90% within 24 hours. So when something happens where there's an abduction and there's an intent to murder, it happens very, very fast. So unless you get on it like immediately, there's not much you're unfortunately going to be able to do about it. But it supports this point. The fear is huge because if something happens, it's so quick to go south, but the frequency is very low. So it's horrible, but not overly common. But I will say there is a broader street risk. In 2024, 1.95%, just under 2% of children aged 12 to 17 reported at least one violent victimization while walking out on the streets. Now, that's a very vague term, and it wasn't overly well defined, so what do you count as violent can be debated, but 2% of the kids walking around out there, you know, it could be something as simple as somebody throwing a snowball at them, which we found out in the state of Wisconsin is like a Class B felony or something like that now. So, something to bear in mind. But in the pro-walk argument, the most measurable danger is the cars. It's not the creeps. And it can probably be mitigated with the routes that the children would walk. Are they walking in groups? Are they paying attention at crossings? Stuff like that. So that's side A of that argument. Now, side B, talking about private messaging. NCMEC, the cyber tip line there, reported that in 2024, it received 546,000 reports of online enticement. That is up 192% from the prior year. So if you thought it was bad, in 1 year, it got way worse. They define online enticement as adults communicating with a child for sexual purposes, and it includes sextortion. NCMEC also reported nearly 100 reports per day of financial sextortion in 2024. And since 2021, they're aware of more than 36 teenage boys who committed suicide directly from being a victim of sextortion. So there is something there for sure. To give you a little bit of scale context, the cyber tip line there received 20.5 million reports in 2024. And NCMEC notes the problem is globally distributed. A large share of it comes from outside of the United States. So it's not just U.S. citizens who are going after U.S. children. But if you look at the whole thing globally coming into the United States, 24.5 million reports. So the FBI describes financially motivated sextortion patterns. Offenders often pose as peers, pressure teens into explicit images, and then demand money. They've also issued notices to banks about financially motivated sextortion as increasing threat, so they're trying to get the banks to monitor for clues of this happening. But bottom line is, walking home exposes your kid to a random risk, but if they have access to DMs and private communications and stuff like that on the internet, it exposes them to a targeted risk. It makes them a target as opposed to more likely a victim of random incident, like a car accident. However, there is some pro-messaging data. NCMEC also reports that 68 children were rescued in 2024 due to Amber Alert activation, and that happened real quick because of all the cell phones around. So if children have cell phones, they're getting these Amber Alerts, and they can say, oh, that's Johnny. I just saw Johnny over there. So there's a positive for it there. Research from NCMEC also shows that parents widely use digital location traffic, which can enable more independence while still being able to allow you to track your child. So there's that benefit. So you can say that a kid with a phone can call for help. They can share their location. They can coordinate rides. It's a safety tool if you leave them out of direct messaging. So those would be kind of the arguments for and against the idea of, is it better to have them walk alone with a phone, or walk home alone rather, or to have them be supervised outside but have a cell phone? So real quick before we go, put a 1 in the chat if you think they'd be better to just walk home alone, or 2 in the chat if you think they should be supervised outside but have access to a phone. I mean, which would you rather see them have? The ability to walk or the ability to have a phone? If you could only choose one. For me, I think you let them walk home. You know, somehow I survived my childhood without a cell phone, but being able to go outside and play. I'm just saying. But think about that today as you're going about your business and mull it over. You would go with 3, blending of both. Wahoo. Yeah, I mean, I put the argument out there if you could only pick one, but in a perfect world, sure. Maybe it's, I would say maybe it's a flip phone, but those aren't going to have the tracking capabilities. So I don't know if that's the answer either. But that's the problem, is if you give the child the technology, how do you 100% keep them out of these danger areas? And you don't. But I suppose you could make the argument that it probably comes down to teaching them how to handle things, much like you teach your child how to watch for cars and cross the road and stuff like that. Though I would say if you're talking about how to navigate the roadways, it's a lot more black and white. It's a lot more rules-based than it is if you're trying to teach them how to navigate and stay safe online, which involves a lot more trickery. There's not as much trickery out on the road with somebody going, haha, I'm going to trick this kid and then I'm going to hit him with my car. No, it's an accident, where there's a lot more deceit and deception that goes into the online risk. So there's that. All right, let me catch up on your thoughts before we call it here. Things are kind of weird these days, and it's a lot harder to understand risk. That's very true, Charles. It is very hard to understand risk, which is, I suppose, an argument that the world has gotten way too complicated. There's a push, especially in Gen Z right now, towards simpler things and simpler times. And these are probably some of the reasons why. It's too complicated. You can't figure out how to navigate it. It doesn't make any sense. And it's probably going to be the end of us if we keep down this road. So I get why Gen Z especially is pushing towards simpler times and older days and all of that. It makes sense to me. Barbara says even parental controls aren't guaranteed. I totally agree with you. So anyways, I just wanted to share that with you. I took the thought pattern from yesterday and advanced it a little further into a what would I rather have. And for me, there's a phrase that I use throughout my life, and I'd encourage you to consider it. And that's that living causes death every time it's tried. And it's very true. There's risk in everything. We're all eventually going to leave this planet and leave this life. So at some point, you have to accept the fact that every day could be your last. Every day could be the last for those that you love. And you just have to live a little bit. And that would, I suppose, be my argument when it comes back to the 80s and the 90s that we talked about yesterday, as we went through the milk carton kids into the stranger danger and all of that. And we developed this fear that, oh my goodness, our kids are going to die, so let's move them all inside. I don't know that it helped us any. I mean, it's sad when stuff happens, especially to a child. It's sad when they leave the world so young, but there's always a risk to everything. And there has to be something said for just living. So I'll leave it at that. Again, apologies for the delayed overtime, or shortened rather overtime today, but we do have to go do other things. We'll be back tonight though, and I will be here 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. Thank you all for joining me. Go have yourselves a good Tuesday, and I cannot wait until tomorrow morning to see you all again, because this is, I've been honest with you from the jump here. I view this as a job, because if I'm going to put this much time into it, I have to make money at it. So I treat it like that. But if you also know me, you know that anything I treat as work and a job, I treat with a whole lot of respect, which means I treat all of you with respect, or at least I surely try to. And bottom line, this has been one of the best jobs I've ever had, because I get to spend my time with you. So thank you all so much. Take care. God bless.